Have you completed the assignment? The two questions that I had given for the assignment. Okay. I have also uploaded the model answers of those questions, right? So in the all the Telegram groups, I have uploaded those. Do I need to discuss those questions or is it fine? Yes. Is there need to discussion of those questions? No need, right? Okay, perfect. Because the frameworks are same. Okay. Okay. So today we will be doing the judiciary. Okay. So mostly with respect to the judiciary, the important aspects that you need to understand, firstly, one or the nature of questions that they ask with respect to the judiciary. Firstly, is with respect to the philosophy. Okay. What constitutes philosophy, that I will explain later. Second is with respect to composition. Okay. Third is with respect to the functions. And fourth, and the most important one is with respect to, or the recent trend has been with respect to EDR. Okay. So mostly with respect to the philosophy of the judiciary or the philosophical question, generally what they ask is with respect to the appointment or removal. Okay. This year I was expecting a question on the removal of the Supreme Court judges because it was in news. But instead what they asked was on the collegium system. ठीक है. So next year यूपीएससी has that habit कि अगर इस साल करंट अफेयर्स में वो क्वेश्चन है तो वो नेक्स्ट ईयर पूछेंगे. जैसे द सेकंड क्वेश्चन ऑन द जुडिशरी दैट दे आस्क्ड वाज ऑन द ट्रिब्यूनल रिफॉर्म्स एक्ट. So Tribunal Reforms Act was passed in 2021. ठीक है. That. But next year you can expect a question with respect to the removal. Second aspect of the philosophy is the separation of power. So it is basically with respect to the judicial independence. Okay. And third aspect of the ठीक है, यही दो मेजरली एस्पेक्ट्स पे पूछते हैं. विथ रिस्पेक्ट टू द कंपोजिशन, अगेन they will ask you with respect to the women representation. ठीक है. With respect to, they can ask with respect to the vacancies. ठीक है. Or with respect to the pendency. With respect to the functions, they can ask with respect to the judicial review, the role of Supreme Court as the protector of fundamental rights. ठीक है. Next year, you can expect a question on Article 143 as well. Okay. So Article 143 is the advisory jurisdiction. So recently, the President referred the matter with respect to the veto powers of the governor under Article 200 and 201 to the Supreme Court. So you can get a question on that. The second thing which was in news was with respect to this Article 141 and 142, which provides the special power to the Supreme Court. So Article 141 basically provides for the legislative power to the Supreme Court, okay, under which whatever judgment Supreme Court has given has the force of law. Okay, so that Article 141 was given to fill the legislative vacuum. जैसे आपके विसाखा गाइडलाइंस थे, विसाखा गाइडलाइंस were given to prevent the sexual harassment at workplace, right? So during that time there was no law. So Vishaka guidelines acted as the law until 2013 when Prevention of Sexual Harassment at Workplace POSH Act was passed. Okay, and Article 142 gives the executive power to the Supreme Court, okay, under which Supreme Court can take the policy decisions. So executive के जो decisions होते हैं वो Supreme Court लेता है. जैसे ban on firecrackers. So ban on firecrackers was basically the policy decision. Similarly, odd even policy, right? Similarly, you also had the Supreme Court cancel the allocation of coal blocks. ठीक है, ये सारे डिसीजंस एग्जीक्यूटिव ने लेने होते हैं बट सुप्रीम कोर्ट टुक. सो फॉर द सेक ऑफ कंप्लीट जस्टिस, सुप्रीम कोर्ट कैन टेक द एग्जीक्यूटिव डिसीजंस. तो इन पे अपार्ट फ्रॉम दैट व्हाट यू कैन गेट क्वेश्चंस ऑन की जैसे डिजिटाइजेशन ऑफ जुडिशरी. ठीक है. सेकंड, with respect to the composition you can get the question ki I am also expecting a question on this, issues with lower judiciary. ठीक है, majority of the or all of the questions till now have been on the higher judiciary only, but later judiciary has or the lower judiciary has been the neglected topic. So next year you can expect a question on the lower judiciary. I have added that into our X factor note, so you can cover it from there. Then रिसेंट टाइम्स में अगर आप देखोगे तो मोस्ट क्वेश्चंस हैव बीन ऑन द एडीआर. ठीक है, सो एडीआर में आपके कौन से आते हैं कि एक तो नालसा, लोक अदालत, ग्राम न्यायालय. ठीक है. सेकंड, विथ रिस्पेक्ट टू आर्बिट्रेरी ट्रिब्यूनल्स और द ओवरऑल ट्रिब्यूनल्स. ठीक है. सो बेसिकली ऑन दीज टू थीम्स यू लास्ट 8 years में ही 4 बार इसी पे क्वेश्चन आ चुका है. ठीक है. सो नेक्स्ट ईयर ऑल्सो यू कैन एक्सपेक्ट अ क्वेश्चन ऑन द सेम थीम. सो अभी तक इन्होंने नालसा पूछ लिया है, लोक अदालत पूछ लिया है. यू कैन एक्सपेक्ट अ क्वेश्चन ऑन द ग्राम न्यायालय और यू कैन क्वेश्चन एक्सपेक्ट अ क्वेश्चन ऑन द फैमिली कोर्ट्स. ठीक है. और अगर बहुत ही उनको स्पेसिफिक या नीश टॉपिक पे क्वेश्चन पूछना होगा दे कैन आस्क अ क्वेश्चन ऑन दी स्पेशल कोर्ट्स. ठीक है. सेकंड is with respect to the tribunals. So tribunal maybe they have already asked the question on CAT, Central Administrative Tribunal. You can also expect a question on the tribunals under Article 323B. ठीक है, या फिर overall tribunalization of the justice. You can expect a question on that also. ठीक है. So this is the brief overview of the topic of the judiciary. Now if you see the questions, ठीक है, so in 2018, what they had asked, whether tribunal curtail the jurisdiction of ordinary high courts. So basically on tribunal. Next, the philosophical question, judicial legislation antithetical to doctrine of separation of power. Okay? And it was with respect to PIL. Then you have again philosophical question on judicial independence. Okay? Then representation of women. Then this is with respect to NALSA. ठीक है. देन अगेन पीआईएल. सो पीआईएल पे ही आपके 2 क्वेश्चंस आ चुके हैं. ठीक है, विच इज अगेन इट विल बी इन्वॉल्व इन द फिलोसॉफिकल पार्ट ऑफ इट. ठीक है. नेक्स्ट इज विथ रिस्पेक्ट टू द अपॉइंटमेंट कोलिजियम सिस्टम जो अभी इस साल आया था. ठीक है. देन कैट, सो ट्रिब्यूनल पे सेकंड क्वेश्चन. दिस इज अगेन एडीआर थर्ड क्वेश्चन एंड एडमिनिस्ट्रेटिव ट्रिब्यूनल फोर्थ क्वेश्चन. दिस ईयर आल्सो यू हैड अ क्वेश्चन ऑन दैट. So in last 8 years, out of 10 questions, 4 questions were on ADR only. So ADR is the most important in judiciary. ठीक है. और ऐसा नहीं है कि रैंडमली पूछा है. सो 24 में भी ADR पे पूछा है, 25 में भी पूछा है, 23 में भी पूछा है. ठीक है. और उसके पहले 2018. सो इन लास्ट 3 years ADR पे एक क्वेश्चन आया ही है. ठीक है. और अगर ऐसे देखोगे तो इन लास्ट 3 years अगेन 23, 24, 25 जुडिशरी के ही टॉपिक पे यू आर गेटिंग 2 क्वेश्चंस. सो इन 23 यू हैव 2 क्वेश्चंस. वन इज ऑन फिलोसॉफी, वन इज ऑन एडीआर. 24 अगेन फिलोसॉफी एंड एडीआर. 25 अगेन विथ रिस्पेक्ट टू द फिलोसॉफी दैट इज अपॉइंटमेंट और कंपोजिशन कह सकते हो. सेकेंड इज द ट्रिब्यूनल. सो ये ट्रेंड लास्ट 3 years से चालू है. तो इस साल भी यू कैन एक्सपेक्ट सेम. ठीक है. नाउ कमिंग टू द आंसर राइटिंग फ्रेमवर्क. ठीक है. वन, कि अगर अपॉइंटमेंट रिलेटेड वगैरह प्रोसेस हो, ठीक है, सो इन दैट केस व्हाट यू डू इज यू कैन स्टार्ट विद द कॉन्स्टिट्यूशनल प्रोविजन, ठीक है, आर्टिकल 124। या फिर अगर कंटेम, यस, वन मोर थीम दैट आई मिस्ड वाज कंटेम्प्ट ऑफ कोर्ट। ठीक है, लास्ट ईयर इट वाज इन न्यूज विथ रिस्पेक्ट टू प्रशांत किशोर केस, ठीक है, सो यू कैन गेट अ क्वेश्चन ऑन कंटेम्प्ट ऑफ कोर्ट, ठीक है। एंड अगर उन्होंने अगेन बहुत नीश टॉपिक पे पूछने का सोचा, तो यू कैन हैव द क्वेश्चन ऑन द स्पेशल लीव पिटीशन, आर्टिकल 136। सो इसका बस मैकेनिज्म आप कवर कर लो, दैट इज मोर देन सफिशिएंट, ठीक है, दैट। नाउ कमिंग टू द आंसर राइटिंग फ्रेमवर्क। So again, either constitutional provision, या फिर if the question has the current affairs tone, guys, please turn on your cameras. If the question has the current affairs tone, ठीक है, so in that case you can give the contextual introduction, ठीक है, कि जैसे आपका अगर ये वाला क्वेश्चन है, in 2023 constitutionally guaranteed judicial independence is the prerequisite of democracy, comment. So in that you can either define judicial independence, you can give the quote, या फिर the third one is you can talk about the NJAC judgment. So Supreme Court in NJAC invalidated 99th Constitutional Amendment Act and held that the judicial independence is the basic structure of the Constitution. So that introduction also you can give. ठीक है, so contextual, then data based, data based as in कि कंपोजिशन पे अगर क्वेश्चन आए, जैसे दिस वाज योर क्वेश्चन कि रिप्रेजेंटेशन ऑफ वुमेन, ठीक है, सिमिलरली इफ द क्वेश्चन इज ऑन द हाई जुडिशियल पेंडेंसी और द वैकेंसी, ठीक है, सो इन दैट केस यू कैन गिव द डेटा बेस्ड इंट्रोडक्शन ऑल्सो। और अगर कुछ भी नहीं आए तो you have two quotes. If the lamp of justice goes, we cannot imagine the amount of darkness, Lord Bryce. You can use this quote अगर question has the negative connotation, ठीक है, if the question is on the negative side of the judiciary with respect to the issues वगैरह, so in that case you can start with the quote, या फिर you can use the same quote into the conclusion also, ठीक है। आई विल गिव यू वन मोर कोट जब हम आंसर लिखेंगे, या फिर सेकंड, या अगर सिग्निफिकेंस ऑफ द जुडिशियरी के जैसे कॉन्स्टिट्यूशनली गारंटीड इंडिपेंडेंस ऑफ द जुडिशियरी वो वाला क्वेश्चन है, या फिर डिस्क्राइब द रोल ऑफ जुडिशियरी एज द गार्डियन ऑफ द फंडामेंटल राइट्स, इफ द क्वेश्चन इज ऑन दैट लाइंस कि वेयर यू हैव टू हाईलाइट द significance of judiciary, then you can use this quote. Indian constitution envisions a fiercely independent and active judiciary to strengthen this process of social reform, ठीक है, which can be seen in extraordinary powers granted under 141 and 142, ठीक है। अब ये सेम इंट्रोडक्शन व्हाट यू कुड हैव यूज्ड इन दिस पर्टिकुलर क्वेश्चन, ठीक है। सो हु आर एंटाइटल्ड टू रिसीव फ्री लीगल एड, the Indian constitution envisions a free legal aid is under which article? Yes, free legal aid is under which article? Hmm? 39A, right? So Indian constitution envisions a fiercely independent and active judiciary to ensure, क्या क्वेश्चन है, the access to justice through free legal aid under article 39A, ठीक है, ऐसे you can rephrase it. Then in main body, ठीक है, if with respect to the significance you can use the pies approach, ठीक है, कि जैसे पॉलिटिकल सिग्निफिकेंस या फिर कॉन्स्टिट्यूशनल, पॉलिटिकल मीन्स उसमें पॉलिटिकल आता है आपका, लीगल आता है, कॉन्स्टिट्यूशनल आता है। ठीक है, तो उसमें वन, विथ रिस्पेक्ट टू इंश्योरिंग द अकाउंटेबिलिटी, इंश्योरिंग रूल ऑफ लॉ, डेमोक्रेसी और प्रोटेक्टिंग द डेमोक्रेसी। ठीक है, और इंश्योरिंग कॉन्स्टिट्यूशनल सुप्रीमसी। ठीक है, इंस्टीट्यूशनल में गार्डियन ऑफ द कॉन्स्टिट्यूशन, जुडिशियल रिव्यू, जुडिशियल इंडिपेंडेंस, इकोनॉमिक, इंप्रूविंग ईज ऑफ डूइंग बिजनेस। ठीक है, सो द जुडिशरी और द functioning of the judiciary is also one important aspect of ease of doing business. Okay, otherwise what happens, as in case of India, majority of your PPP projects end up in litigation, and because of the delay that happens, ease of doing business. ठीक है, जब हम इकोनॉमिक्स में पीपीपी करेंगे देयर यू विल लर्न इट, वन ऑफ द मेजर इशू इज द लिटिगेशन। ठीक है, बिकॉज ऑफ पुअर कंसेशन एग्रीमेंट्स। देन एप्लीकेशन ऑफ लॉ एंड सोशल, access to justice, protection of fundamental rights, rights of vulnerable, social reforms through progressive judgments. ठीक है, दिस इज वन। इश्यूज के लिए व्हाट यू डू इज स्टेपल। ठीक है, सो स्टेपल एज इन it is similar to the pestle only, but I prefer staple specifically in GS3 also for economics, because जो आपके कोर स्ट्रक्चरल इश्यूज होते हैं वो सबसे पहले आते हैं। ठीक है, कि जैसे पेंडेंसी, मल्टीप्लिसिटी ऑफ द लॉज विच क्रिएट्स द कंफ्यूजन, देन टेक्नोलॉजिकल, डिजिटल डिवाइड, लैक ऑफ डिजिटल इंफ्रास्ट्रक्चर, एडमिनिस्ट्रेटिव एंड इंस्टीट्यूशनल में वैकेंसी, प्रोसीजरल इश्यूज कि जैसे इनकंसिस्टेंट बेल, this inconsistent application of bail provisions, or the excessive this what to call adjournment culture in the judiciary. ठीक है, लो वुमेन रिप्रेजेंटेशन, पॉलिटिकल में issues with respect to appointment, then issue of government litigation. So around 78% of the cases pending in higher courts are against the government. ठीक है, so government is the biggest litigant in Indian judiciary. ठीक है, सो पेंडेंसी गवर्नमेंट की वजह से ही है। देन लीगल कॉन्स्टिट्यूशन, अगेन मल्टीप्लिसिटी ऑफ द लॉज एंड पुअर अकाउंटेबिलिटी मैकेनिज्म, जो अभी आप देख रहे हो जस्टिस वर्मा। एंड सोशल, लैक ऑफ एक्सेसिबिलिटी, अफोर्डेबिलिटी एंड रिड्यूसिंग ट्रस्ट इन जुडिशरी, which results into people seeking alternative mechanisms like खाप पंचायत, राइट, व्हेन दे, जैसे आप कहते हो कि आप कोर्ट, यू शुडंट गो टू कोर्ट, सो जो अल्टरनेटिव मैकेनिज्म्स होते हैं, ठीक है, पीपल उनके पास जाते हैं। देन इन वे फॉरवर्ड कमिटी रिकमेंडेशंस, एडीआर, डिजिटाइजेशन और इंफ्रास्ट्रक्चर, कंक्लूजन कोर्ट। ठीक है, नेक्स्ट थिंग यू नीड टू रिमेंबर इज विथ रिस्पेक्ट टू द फंक्शंस। ये भी अगर फंक्शंस याद रखोगे, बेस्ड अपॉन दैट ऑल्सो यू कैन जनरेट लॉट ऑफ पॉइंट्स। द कोर प्रिंसिपल फंक्शन ऑफ द जुडिशरी इज एडजुडिकेशन, राइट, तो वो तो फंक्शन है। देन इंटरप्रिटेशन ऑफ द लॉ एंड जुडिशियल रिव्यू। ठीक है, द थर्ड वन इज गार्डियन ऑफ फंडामेंटल राइट्स। फोर्थ, सुप्रीम कोर्ट इज ऑल्सो द फेडरल कोर्ट, so it protects the federal distribution of power or the federal balance, right? Next, supervisory jurisdiction. So Supreme Court and High Court exercise supervisory jurisdiction over the lower courts because India has integrated judiciary. Yeah. Next, ensuring supremacy of the constitution and separation of power. ठीक है, जो जुडिशियल इंडिपेंडेंस वाले वगैरह जो क्वेश्चंस आएंगे उसमें ये पॉइंट आएगा। एंड स्पेशल पावर्स अंडर आर्टिकल 141, 142, ये दोनों मैंने ऑलरेडी एक्सप्लेन किया है। देन एडवाइजरी jurisdiction. So these are the functions or the powers of judiciary which you need to remember. Based upon that, you can also generate the points. ठीक है, इज इट क्लियर? ओके, एनी डाउट्स? जस्ट रेज योर हैंड. Only those who raise the hand on the cam, I will give them a chance. ठीक है, चैट पे वगैरह कुछ नहीं आज. ठीक है, ओके, क्लियर है. ओके, चलो. So this is with respect to judiciary. Tribunals we will do at the end. So first question is, we'll take the philosophical question. Constitutionally guaranteed judicial independence is the prerequisite of democracy. Comment. Okay, Nitesh, it is fine. Those who have the genuine reason, they can turn off their cameras. It's fine. Okay. Okay. So who wants to give me the structure of this particular question? Yes, it अब तो बहुत सिंपल है. Who wants to give me the structure? फास्ट. आज हमें 10 क्वेश्चन करने. मैं 9 बजे तक लेक्चर लूंगा फिर. यस. Who wants to give me the structure? Okay, good. उदय. ओ, एक सेकेंड. कहाँ गया? Just raise your hand. I will unmute. किसी को नहीं आ रहा है? What is the difficulty in this? Yes, Vasundhara. एक सेकेंड. Yes.
So we can start off with the introduction. मतलब उसमें article 50 दे सकते हैं, separation of powers. And then we can with this the main body we can start like why the judicial independence is prerequisite of democracy. I mean
Okay.
before that we can
Importance
also,
of judicial independence.
yes sir.
ठीक है. What else?
And then the constitutional guarantees we can mention in a diagram like article 50,
Good.
article
वो तो
124.
इंट्रोडक्शन में ही आपने यूज किया है फिर तो.
Yes sir. And then so that is comment. So we can also mention कि judicial independence के साथ में there should be constitutional supremacy and constitutionalism. मतलब वो point भी डाल सकते हैं. मतलब 2-3 points
मतलब
because
कैसे?
it should
What will be the
prevent.
rule that you are going to follow?
So 60-40.
नहीं, कमेंट के लिए कहाँ से 60-40 आ गया? That is the opinion based question. When they ask you what do you think or do you agree, उसके
So
लिए है ना.
70-30 फिर.
Yes, 70-30 या फिर 80-20, whatever. तो 30% में you go the counter argument. That
Yes
is
sir.
the issues with or the issues arising of it. ठीक है, फिर challenges to judicial independence.
Okay sir.
ठीक है. Who else? Yes, we have new one, Ajay.
Good evening, sir.
Yes.
Sir, in the intro part, as you have mentioned, we can introduce with NJAC judgment.
Introduce with?
NJAC judgment, judicial independence.
Okay, NJC. Judgment
Yes.
you are talking about.
Yes, sir.
Okay, so
Then
contextual introduction.
Yes.
Then
in the body part, we have to say in the heading, constitutionally guaranteed judicial independence is a
yes,
prerequisite for democracy.
constitutional guarantee. Constitutionally guaranteed.
Guaranteed.
Okay.
Yes,
So
sir.
in this,
So
what
we
you will
have,
write?
I'll write Article 50, 121, 122, and the constitutional Article 13.
ठीक है.
Then we have to highlight the challenges and way for a conclusion.
ठीक है. Okay, good. Tavishi, how are you going to generate the points into this? Importance of judicial independence.
Okay. Okay, so before that, I just wanted to mention one point as well. So, should we make a small diagram about the prerequisites of democracy? So, like,
ठीक है, you can mention. At the end, you can go for it. ठीक है. Otherwise, not needed. Okay, because you already have constitutionally guaranteed, which you have to elaborate. Then independence of judiciary challenges is also there. Then implicitly way forward will also come.
got
Because
it.
unnecessary that will be fourth or fifth.
Got it.
ठीक है. Yes. So independence of judiciary, how are you going to generate the points?
Ensuring accountability of executive and legislature through 141, 142.
Okay, so what framework you are going to use?
Okay, for judicial independence, again, I guess pi we can use.
And you use the functions, no?
Okay,
So functions. So judicial review or the interpretation or the review prevents. What does it prevents? Hasty legislations or the arbitrary legislations, right? Which is important for democracy. Then guardian of the fundamental rights, protection and promotion of
citizen.
the fundamental rights of the citizens. You give the example. ठीक है.
Yes.
Then maintains federal balance. Example, SR Bhumi. Then ensuring supremacy of the constitution. Right. Example, then again
Basic structure
NJC you can
doc-
give or the you can talk about
Basic structure doctrine we can.
basic structure doctrine. Then special powers
Yes.
to promote the social justice and democracy. यहाँ पे you give Visakha guidelines. यहाँ पे you give any recent
Liquor
judgment
ban.
with respect to judgment on the Article 200. ठीक है. वही है. Then advisory jurisdiction also you can create a point. ठीक है, to ensure the rule of law and to ensure the this consistent application of the constitutional provisions or the interpretation of the constitutional provisions. वही आएंगे. ठीक है. Then challenges again, इनमें से कोई भी आप 3 challenges उठा लो. सबसे मेजर चैलेंज तो आपका आएगा ओवर रीच, right? Then it goes against separation of power, ठीक है, judicial independence. And the third, it leads to hmm, what else?
Pendency.
ठीक है, हाँ, pendency of cases limits the access to justice. हो गया. ठीक है. Okay. Privilegization of judicial activism, yes. ठीक है. So that so in based upon that you have to generate the points, and then in conclusion you use the same quote: if lamp of justice goes, we cannot imagine the amount of darkness. Lord Bryce. ठीक है. And independence of judiciary is essential for that lamp. ठीक है. वो वैसे. Okay, so you guys want to try?
Yes, sir.
Hmm?
Yes,
So
sir.
it's 5:32. You have time till 5:39. Yeah, I'm keeping this one. So you can generate the points from here. Yes, I want to see everyone writing, please. 8 minutes हो गए. Finish. Introduction. Again, let's keep cameras turned on, please, so I can see who exactly is writing and who is not. ठीक है, ये कोई YouTube पे या कहीं नहीं जाने वाला है. ठीक है, so don't worry. Okay, so introduction is key. One is you can give the quote from the answer writing framework. This quote नहीं, mostly the data based introduction या फिर definition based introduction. ठीक है. So database, what could be the data-based introduction in this? Again, there are two alternatives. One is I have gone with the definition, but there can be a data-based introduction also. What can be the data-based introduction? Sorry, not in this one. Okay. Not in this one. One is the quote-based introduction. I was thinking about the second question. And the second is this definition-based introduction. Okay. So I have gone with definition-based introduction. You can go with the quote-based introduction also. That is also fine. You can go with the context also. NJAC. But as I wanted to use the NJAC judgment in the main body, I avoided that using into the introduction. So even if you have used that into introduction, that is fine. कोई problem नहीं है. ठीक है? So judicial independence refers to freedom of judges from external pressure, political or popular. Political pressure means pressure from executive. ठीक है? Popular pressure means pressure from people. कि जैसे आपका सबरीमाला वर्डिक्ट था, वी हैव लर्न द कंसेप्ट ऑफ कॉन्स्टिट्यूशनल मोरालिटी एंड सोशल मोरालिटी. ठीक है, जुडिशियल इंडिपेंडेंस एज अ पार्ट ऑफ बेसिक स्ट्रक्चर, दैट ऑल्सो यू कैन राइट. बट अगेन 99% ऑफ द एस्पिरेंट विल राइट दैट ओनली. ठीक है, यस, इंडियन जुडिशरी इज नॉट ओनली गार्डियन ऑफ कॉन्स्टिट्यूशन बट ऑल्सो एक्टिव पार्टिसिपेशन इन सोशल रिवॉल्यूशन. दैट ऑल्सो यू कैन यूज. गुड. ठीक है, दैट. So judicial independence refers to freedom of judges from external pressure, political, popular, enabling them to uphold constitution and rule of law without fear and favor. ठीक है, this is one definition based introduction. आपने दूसरा भी quote दिया है या context दिया है, those are also fine. ठीक है, then constitutionally guaranteed judicial independence. So how constitution has guaranteed separation of power under Article 50, security of tenure under Article 124 and 217. Okay, you have financial autonomy, that is funds or the expenditure charged upon the consolidated fund of India. Then contempt of court powers, Article 129 and 215, under which the Supreme Court and High Courts are the courts of records. They have the contempt power to uphold the dignity of the judiciary. Then judicial review ensures judicial independence or the separation of power. Then appointment process 124 or the appoint 124 147. This. Okay. Then judicial independence as prerequisite for democracy. Again, if you see the points, one, rule of law. An independent judiciary safeguards rule of law over rule of power, ensuring that all state action remains within constitutional limits. Okay. So one aspect is a rule of law. Second, guardian of fundamental rights. It should be fundamental rights. Constitution is also fine. Guardian of fundamental rights guards the constitution by protecting citizens' fundamental rights from legislative and executive encroachment. Example, Shreya Singhal case invalidated section 66A of IT Act. Right. Third, separation of power to prevent concentration of power. Okay, that. Then you have ensuring constitutional supremacy, act as a bulwark against populist and authoritative tendencies. Develop just the vocabulary. Dimensions are the same, which we have discussed in the answer writing framework. So act as a bulwark against populist and authoritarian tendencies. You can also mention act as a bulwark against majoritarianism. Okay. Example, basic structure, doctrine. Then government accountability, government through judicial review. Example, NJC case. Okay. Or you can give this verdict, Vinit Narayan judgment. No, that was related to the CBI. वो केस भी हमने पहले किया था, ठीक है। देन और प्रकाश सिंह बादल गाइडलाइंस with respect to police reforms. Then uphold constitutional morality by progressive interpretation of laws. Example, Sabrimala verdict, Puttuswamy judgment. Then prevents executive overreach. Independent courts can strike down arbitrary laws and actions. Example, Indira Gandhi judgment. And peaceful resolution of disputes, which is also essential for democracy. Right. So credible judiciary provides non-violent conflict resolution, strengthening democratic stability. Okay. Example, Ayodhya Babri Masjid judgment. Where they held the balance. The balance judgment दिया था, because of which there were no riots. Okay, so peaceful resolution of disputes. So this is your 70%. Rest 30%. Challenges way forward. Again, यहाँ पे 4 देने की जरूरत नहीं है. 2 are also fine, 3 are also fine. ठीक है. So lack of transparency in collegium. यहाँ पे ब्रैकेट में remember this keyword always. One is judges appointing judges, या फिर second which was held by law commission is uncle judge syndrome. ठीक है, कि where only the relatives of the current judges are appointed. That is called as, yes, Gogoi appointment. Former CJI Justice Chandrachud, the present CJI, okay, his father was also judge. Former CJI's father was also judge. Okay, so basically it is called as uncle judge syndrome, which is the sign of nepotism. Okay, then post retirement appointments, it again impacts the independence of the judiciary. Then allegations of corruption, the recent case, and judicial overreach criticism. Okay. Then early finalization of MOP. MOP is the memorandum of procedure. So after the नहीं डायरेक्ट नेम अवॉइड करो, ठीक है. तो आफ्टर द NJAC judgment, what Supreme Court and government are doing is finalizing the memorandum of procedure, under which the procedure of appointment of judges is codified. ठीक है. Then cooling off period for post retirement appointments, 2-year cooling off period दे दो. So then next, judicial accountability, passing of judicial accountability bill, okay, which lapsed, I think in 14th or 15th Lok Sabha. Then for judicial overreach, adhering to judicial restraint and separation of powers. ठीक है. This. So if you see in the entire answer, we have given almost कितने 7 or 8 Supreme Court judgments, but 8 में से एक भी नया नहीं है, except for बाबरी मस्जिद, that is also well known. सारे के सारे हमने जो प्रीवियस लेक्चर्स में किए वही रिपीट हो रहे हैं. सो माय पॉइंट इज कि आपके वही रिपीट होंगे. You just have to consolidate from these answers. You have to write with me. वही सुप्रीम कोर्ट जजमेंट्स रहेंगे. इट इज अ सेट ऑफ 15 to 17 जजमेंट्स. वही आपके अक्रॉस पेपर्स आएंगे. ठीक है. ठीक है. एंड कंक्लूजन, जस्ट नोट डाउन दिस कोट. Again, this is of Lord Price only. There is no better test of excellence of government than working of its judicial systems. ठीक है. इसके आगे यू कैन सिंपली ऐड judicial independence forms the core of this excellence. Yes, this can also be written into the introduction. I'm just giving you 3 to 4 quotes per answer. अब यही आंसर मैं कल लिखूं तो I will have the different content. ठीक है. बेसिक जो फैक्ट्स रहेंगे, that is judgments will remain the same. Only the keywords will change. because of the vocabulary that I have. Okay, is this clear? Okay, so next question is discuss the desirability of, अगेन ये भी फिलोसॉफिकली है, यहाँ पे बस आपकी वोकेबुलरी टेस्ट होगी, नथिंग एल्स. ठीक है, डिस्कस द डिजायरेबिलिटी ऑफ ग्रेटर रिप्रेजेंटेशन ऑफ वुमेन in the higher judiciary to ensure diversity, equity and inclusiveness. ठीक है, okay, who wants to try the structure? Yes, someone new please. Yes, Rameshwaram, and then Kushi you can try.
Good evening, sir.
Yes, थोड़ा सा जोर से बोलो please.
Okay, sir, in this question, I would like to start. I would like to paraphrase this question.
Okay.
Then, why women representation is needed, where I would like to highlight these terms: diversity, to ensure diversity, then some points, then to maintain
No,
equity
give me
and
the introduction. What will you write into the introduction?
sir, in introduction, I can write there is already a lower number of women representation in India. Only 11 women in Supreme Court.
Okay, so basically you are talking about data-based introduction.
Yes, sir.
Okay. Then next.
Then why women representation is needed?
Hmm.
Where I will use these terms: diversity, equity, and inclusiveness to maintain these terms.
Okay, so you will classify your points under these three:
Yes.
diversity, equity, inclusiveness.
And then present status briefly.
Hmm.
Challenges, present status.
Okay.
Then
Present
challenges
status
and
तो आपका data ठीक है, present status. Hmm.
challenges and way forward together, or then conclude.
ठीक है. Then conclude. Okay. Fine. Anyone else? Kushi, you can unmute. Rohit, you can try next one.
Okay. So this is my first time, so I am not sure if I'll be able
Don't
to
worry, don't worry.
try.
Just try.
I was thinking if we can try a context-based introduction. Recently, there was a controversy regarding Supreme Court judges' appointments, and Chief Justice Nagaratna, she was against the appointments that were made. They were not transparent, and women judges were not appointed.
So basically, recently
Context-based.
in the collegium discussions, there were two senior most women judges, but they were bypassed to recommend the male judge who had the 57th rank in the seniority.
Right.
Okay.
So can we say that in the introduction?
Yes, you can give the contextual one.
And can we also point out that India has not had a female Chief Justice yet?
Yes. No female CJ. ठीक है. Next.
Sir, I'm not able to see the question.
Okay.
Okay, and then I will have the subheading of desirability of greater female representation in higher judiciary, and then I might classify the points under.
Okay.
Uh,
This structure is fine. ठीक है, यही structure रहेगा. Tell me how are you going to generate these separate points under these three? Or should we go for it?
So there can be another framework to it rather than diversity, equity, and inclusiveness.
What is the another framework that you don't classify under these three?
I don't know.
Either you classify the points under these three, or you simply give one heading, desirability, and under it you write the points.
Right. Okay.
ठीक है? Yes. So how are you going to generate the points?
Can't think of any, sir.
ठीक है. Okay.
Yeah.
No worries, no worries. That's good you participate. See, even a child takes around 1.5 years to walk. ठीक है, first he crawl. Okay, at the first, even on the birth, he can't even do that. Okay, after 6 months, he try to, or he learn to crawl. Then after 1 year, he learn to walk. Then he runs. ठीक है, दूसरे दिन ऐसे कोई नहीं होगा कि आप रन कर रहा है बच्चा, वो सिर्फ मूवी में। ठीक है, तो डोंट वरी, जस्ट पार्टिसिपेट। आई गारंटी कि आफ्टर टू, बाय द टाइम वी फिनिश GS2, ठीक है, ऑल ऑफ यू विल बी वेरी गुड विथ रिस्पेक्ट टू द स्ट्रक्चरिंग एंड डायमेंशन जनरेशन। ठीक है, जस्ट पार्टिसिपेट एंड ब्रेनस्टॉर्म विथ मी। ओके, ठीक है, दीपायन, यू टेल मी हाउ आर यू गोइंग टू जनरेट द पॉइंट्स?
Sir, am I audible?
यस यस यस।
Sir, I can start with the quote by Justice Ruth Bader Ginsburg by women should not be women are present in all decision making authorities. It should
ठीक
not
है,
be the provision it should not be the exception that women are not present in the judiciary.
ठीक
And
है,
I can also refer to the quote recently the Justice Bangalore Venkatramya Nagaratna ma'am also told about the representation of the women
आपका पूरा आंसर
needed
वही खत्म हो जाएगा इंट्रोडक्शन में ही। यू हैव टू गिव जस्ट 2 to 2.5 लाइन्स ऑफ द इंट्रोडक्शन।
So then the quotation only is the
यस
introduction,
यस,
and we can
नेक्स्ट।
also write about the why women representation is essential, the needs of
हैज
women
दैट बीन
represent.
आस्क्ड? हैज दैट बीन आस्क्ड?
Yes, sir.
Why? Huh, so basically desirability has been asked. So why women representation is needed?
Yes,
Right.
sir. We have to record reasons for the low representation of the women
No, not
in
needed.
the.
That has not been asked. Okay, reasons for low representation will come into the challenges part. That will be in 30%. Okay, read the question, discuss the desirability of greater representation in higher judiciary. You have to talk about desirability. That is going to consume 70% of your weightage.
Okay,
Right?
okay, sir.
Directive is the discuss now. So 70% should go to
Okay,
desirability.
discuss is the directive.
At the
30 rule
end,
will
just
happen.
30% challenges way forward. So you tell me, how are you going to generate the points under these?
Desirability of greater representation. Sir, we can talk about the gender justice that women are required in the judiciary and no female CGI until now. We
ठीक
can
है?
also talk about the no female CGI until now. We can talk about the lower
You have to
representation of the.
classify the points under these three. So will you classify under these three, or will you just write the points under the
Sir, these three
single
are
heading?
diversity, equity, and inclusiveness.
Hmm?
We can classify under these three
So just
points:
tell me the
diversity,
points under the diversity.
diversity. Sir, lower representation of the women in the judiciary.
तो वो तो ठीक है ना, इंट्रो में हो गया, या फिर ठीक है, चलो ऑन द नेगेटिव लाइंस। व्हाट एल्स?
No female CGI until now.
Those are the negative points. They are asking desirability, why it is needed. So how it will lead to positive. ठीक है, no worries. Tavishi, you can try.
So
Till then, think Dipayan, I will come to you again.
for diversity, we can add they will help in highlighting women
Tell
issues.
me, should we classify the points under these three?
Like,
Or
I
should we
wrote
not?
it just now, like 2 points each. So
Okay.
maybe I can go with it.
ठीक है. Okay, so what will be the points under diversity?
Diversity highlight women issues and role model for communities like other women.
Highlight women issues.
Yes.
But highlight women issues can come into the equity also. And role model can come into the inclusiveness also.
Yeah, actually, when I wrote 6 points and I just classified. So yeah, I'm also not sure. Should be like divide into
Yes.
50 points.
Yes. So the rule that I discussed, कि when you get the word like and, okay, when they give these dimensions in the question itself, you can go for the classification. Okay, but there are just two rules that you apply. One, कि देयर शुड नॉट बी द ओवरलैपिंग ऑफ द पॉइंट्स। ठीक है, कि जैसे अभी इन्होंने कहा कि दैट विल लीड टू द रोल मॉडल। रोल मॉडल कैन बी एडेड इनटू इक्विटी आल्सो, इंक्लूसिवनेस आल्सो, डाइवर्सिटी में तो आएगा ही नहीं। ठीक है, दैट मीन्स वन पॉइंट कैन बी रिटन इन बोथ, मीन्स देयर कैन बी ओवरलैपिंग। एंड सेकेंड, you need to have the separate content for all the dimensions given. ठीक है, which is separate for all the three, there is no overlapping. ऐसा पॉइंट नहीं होना चाहिए कि which can be added under both the headings. ठीक है, so if you can't, or if these two rules are not followed, or if these two rules are not applicable, in that case there is no need to go for the segregation. Segregation is not mandatory. ठीक है, दैट विल आइदर, बिकॉज फिर आपको जनरेट करने में पॉइंट ज्यादा आएंगे। अगर मैं आपको पूछूंगा कि डिजायरेबिलिटी ऑफ ग्रेटर रिप्रेजेंटेशन ऑफ वुमेन इन हायर जुडिशरी, in 30 seconds you will give me 6 to 7 points, but if I ask you to classify under these three you will need more than 1 minute, तो unnecessarily brainstorming time extra हो जाएगा। ठीक है, तो जैसे एक हमने अमेंडमेंट का क्वेश्चन किया था, प्रोसीजरल एंड सब्सटैंटिव लिमिटेशंस, तो वहां पे प्रोसीजरल कंप्लीटली डिफरेंट थे, सब्सटैंटिव कंप्लीटली डिफरेंट पॉइंट्स थे। राइट, इट वाज वेरी इजी टू सेग्रीगेट, इट वाज और यू कैन जनरेट द पॉइंट्स इन अ फास्टर वे। ठीक है, बट जब ऐसे आए कि जहाँ पे आपको लगे कि यार बहुत टाइम जाएगा, या फिर क्लियर सेग्रीगेशन नहीं है, नो नीड टू सेग्रीगेट, यू गिव द सिंपल हेडिंग, अंडर इट यू राइट द पॉइंट्स। क्लियर है? जस्ट फॉलो दिस रूल, इट इज नॉट मैंडेटरी, अदरवाइज इट विल इम्पैक्ट योर स्ट्रक्चर। ठीक है, और टाइम भी ज्यादा लगेगा। Okay, so under the single heading, just remember this rule. I won't be explaining every time. I have taken this much time just to explain that point. So with respect to desirability, okay, how are you going to generate the points on overall desirability? Just give me the framework. Okay, Nitik, you can try, but turn on camera. Otherwise, no. Good, more people are participating. Okay, just tell me, how are you?
So I will give direct points in this.
Sorry, what framework you are
Direct
going to?
point. So direct points.
Oh no, that is fine, direct point. Just tell me what framework will you be using?
So like I will go with like gender sensitivity in the cases
Hmm.
and
Tell me the
increasing public.
framework, not the points. Okay, so let me tell you. Again, use the functional framework. ठीक है, एक तो आपके वही पॉइंट्स है, डाइवर्सिटी, इंक्लूसिविटी एंड इंक्लूसिवनेस। ठीक है, सो डाइवर्सिटी कैसे आएगा? इट विल इंश्योर रिप्रेजेंटेशन टू 50% ऑफ द पॉपुलेशन। ठीक है, सेकंड, डाइवर्सिटी विथ रिस्पेक्ट टू ओपिनियन होता है। ठीक है, सो इट विल गिव यू द फ्रेश और फेमिनिस्ट और द वुमन पर्सपेक्टिव ऑन इंपॉर्टेंट कॉन्स्टिट्यूशनल इश्यूज, जैसे जस्टिस, क्या नाम था, आई एम नॉट एबल टू रिकॉल her exact name, but she provided a descending judgment in the Sabrimala verdict. ठीक है, she was the sole descending woman. ठीक है, with respect to equity, again it can help promote women rights. ठीक है, and with respect to inclusiveness, again women are generally considered more sensitive to downtrodden sections or marginalized sections. Right, that then, so you need तीनों के एक दो पॉइंट्स जनरेट करो, वही लिखो। देन यू हैव फ्रॉम आंसर राइटिंग फ्रेमवर्क, फ्रॉम इट व्हाट यू कैन इंश्योर इज कि दिस, यहाँ से तो नहीं आएगा, बट फ्रॉम हियर इटसेल्फ यू कैन जनरेट द पॉइंट्स, लाइक ये हो गया। Then constitutional, only point you can generate. Constitutional imperative. Which article under the Constitution calls for the equal representation for women? Article 14, right? Or Article 14, 15. Okay. Then greater representation of women again will ensure the greater public trust into the judiciary. Right? What else? Yes. एक पॉइंट मैंने कल भी आपको सिखाया था कि जब ऐसे कोई प्रोग्रेसिव लॉज वगैरह होते हैं, ठीक है, या फिर प्रोग्रेस, यस, इंटरनेशनल बेस्ट प्रैक्टिस, सो इन लाइन विथ ग्लोबल बेस्ट प्रैक्टिसेस. ठीक है. व्हाट एल्स? हाँ, टू एड्रेस जेंडर स्पेसिफिक इश्यू ऑल्सो. किसी ने कहा भी था कि रोल मॉडल इफेक्ट. ठीक है, हो गए आपके यही से पॉइंट्स. ठीक है, दिस इज हाउ you have to think. अब यहाँ पे this answer is going to be completely argumentative. You can't substantiate anything except for this point. यहाँ पे you can give the example of UK, Canada. ठीक है, that. वैसे at the end challenges. So challenges में वही lack of transparency in collegium system, then patriarchal mindset जो कॉमन वुमेन का होता है, या फिर जिसे आप ग्लास सीलिंग सिंड्रोम कह सकते हो. ठीक है, वे फॉरवर्ड में ensuring the or reforming the collegium system. Second, ki quota system also you can introduce. ठीक है, and then third, ki increasing the women in the legal profession itself. ठीक है, how many women lawyers are there in today's class? कोई है? Yes. मेल में कितने हैं? Who is the lawyer in this class? एक ही है. ठीक है, that is also male. ठीक है, so ensuring or enhancing the women in the legal profession itself. ठीक है, and then way forward में same quote you can use. The no better test of excellence of government than the functioning of the judiciary. ठीक है, okay. So right now you have time till 6:17. Yes, gender sensitivity recruitment specific quota for women also. Bar recommendation problem also. Yes, very good. वही यहाँ पे कोई सब्सटेंशिएशन नहीं आएगा. दिस विल बी कंप्लीटली आर्ग्यूमेंटेटिव आंसर. इट इज जस्ट द टेस्ट ऑफ योर वोकैबुलरी. ठीक है, and just to give you a few facts which you can use, presently out of 31 judges there is just one female judge. India has never been, or there was no CJI or women CJI in the history of India, though we have 2 women presidents and 1 woman prime minister. ठीक है, then third, कि only 13% of the HC judges are women. ठीक है, इतने फैक्ट्स अब याद रखो. चलो, you have time till 6:16. Okay, so this desirability of greater representation to women in higher judiciary to ensure diversity, equity, inclusiveness. ठीक है, so what I have done is I have used the quote-based introduction. ठीक है, कि Indian judiciary is not only guardian of the constitution but also active participant in the social revolution, which is of Pandit Jawaharlal Nehru. ठीक है, and greater women representation is essential for this vision. Okay, so I have gone with the code-based introduction. Here you can go with the data-based introduction also. ठीक है, अगर आपको थोड़ा सा कंटेक्चुअल भी या फिर डेटा बेस्ड या फिर अगर और थोड़ा स्टोरी टाइप करना है तो दो इंडिया हैड फीमेल प्राइम मिनिस्टर एंड प्रेसिडेंट्स, ठीक है, ब्रैकेट में इंदिरा गांधी लिखो, यहाँ पे भी नाम लिखो. इंडिया still doesn't, or even after 75 years of independence, India doesn't have the women CGI. That can also be your introduction. Okay, but I have gone with the quote. You can go with the data also. That is fine. Then this is the fact file. Okay, out of the total Supreme Court judges till now, only 4% have been women. No women CGI. As of 2025, only one HC judge and 13% of the High Court judges are women. So desirability, again, constitutional imperative. Polity में कभी भी philosophical question में I always try to give the first point as by linking it to the constitution. So Article 14, 15, 39A ensuring equal opportunity and access to justice for all. Then correct historical imbalance. ठीक है, addresses structural and institutional barriers to legal and judicial careers. ठीक है, historical imbalance as in कि अभी तक सिर्फ 4% ही women were the judges. So that is basically historical injustice. So addresses historical injustice. Next, diversity of perspective. That is, women judges bring unique social insights, empathy, and experiences, enriching judicial or enriching the, you can simply say, quality of judgments. Again, like I said, कि यहाँ पे कोई example नहीं आएगा. This will be just argumentative answer. It is a test of your vocabulary. Then gender sensitive adjudication enhances sensitivity in matters of, then gender specific matters mention करो. Sexual violence, family law, gender rights. Example, justice, yes, it was Indu Malhotra. Indu Malhotra's dissent in Sabrimala verdict. ठीक है, अगेन सेम सबरीमाला वर्डिक्ट हमने पहले भी लिखा है. देन एनहांसेस लेजिटिमेसी एंड पब्लिक ट्रस्ट. ठीक है, जुडिशरी रिफ्लेक्टिव ऑफ सोसाइटीज डाइवर्सिटी strengthens citizen confidence in judicial impartiality. Okay. Then democratization of judiciary, promote inclusive representation across gender, class, region, aligning with democratic ideals. या फिर प्रीवियस क्वेश्चन ही अगर आप यूज करते कि गिविंग द इक्वल रिप्रेजेंटेशन टू द वुमेन इज द डेमोक्रेटिक इंपेरेटिव, देन ग्लोबल डेमोक्रेटिक बेंचमार्क या फिर ग्लोबल बेस्ट प्रैक्टिस. कंट्रीज लाइक कनाडा, यूके हैव अचीव्ड नियर जेंडर पैरिटी, इंप्रूविंग जुडिशियल बैलेंस एंड इंक्लूसिविटी. तो अगर आप देखोगे क्वेश्चन में जो वर्ड्स मेंशन किए, इक्विटी, इंक्लूसिविटी एंड डिजायरेबिलिटी, वो सॉरी डाइवर्सिटी, वो तीनों हमने कभी ना कभी यूज किया. Yes, uncle judge, uncle judge syndrome is different. That is nepotism, and opacity in appointment is lack of transparency. That is secrecy in consultation of the collegium system. Okay, and then role model effect, inspiring women in the legal profession, helping address underrepresentation in senior judicial positions. Then challenges again, opaque collegium system, structural barriers in legal profession, सोशो कल्चरल बायस, दैट इज द पैट्रियार्की. यहाँ पे अब सिर्फ सोशो कल्चरल बायस, इसके आगे ग्लास सीलिंग इफेक्ट लिख सकते हो. ठीक है, देन डाइवर्सिटी क्राइटेरिया इन जुडिशियल अपॉइंटमेंट्स. बेसिकली यू कैन टॉक अबाउट द कोटा सिस्टम और रिजर्वेशन, encourage women in bar councils and tribunals. ठीक है, एस्टेब्लिश इंस्टीट्यूशनल मेंटोरशिप एंड लीडरशिप प्रोग्राम्स. तो रोल मॉडल जहां पे भी आएगा, करस्पॉन्डिंग आपका मेंटोरशिप का पॉइंट वे फॉरवर्ड में आएगा। ठीक है। देन कंक्लूजन, देयर इज नो बेटर टेस्ट ऑफ एक्सलेंस ऑफ गवर्नमेंट देन वर्किंग ऑफ इट्स जुडिशियल सिस्टम। द ट्रू measure of that excellence lies in gender equality in judiciary. Okay, if you want, you can go with the SDG also. What is the SDG for gender equality? ठीक है, 4 की 5, SDG 5. ओके, ठीक है, दैट ठीक है, ये क्लियर है? एनी डाउट्स? Yes, just note down the keywords, that's it. Okay, next. Who are entitled to receive free legal aid? Assess the role of National Legal Service Authority in rendering free legal aid in India. Okay, who wants to give me the structure? Yes, Gautam.
Yes, for me, that first of all, I will write regarding the 39A of that Directive of State Policy, which provides National Legal Service Authority.
Which one?
Creation of 39A
Okay.
ensures free legal aid to socially backward people. That I would write like we have provisions. With this, we have created, for that reason, we have created National Legal Service Authority, which guides and recommends policies for the state legal service authority, at the same time for district legal service
Yes, that's fine.
authority as well.
Just give me the structure.
Then, sir, I will come to the body part. Who are entitled to? Basically, I will write the beneficiaries, that who are the entitled to get this free legal aid. That I will write. With regard to women's and labor also, labor law also, it is
Don't
applicable.
give me the points, just give me the structure. Next.
Then I will come to the second part, that access the role of National Legal Service Authority.
Your voice
What
is
the role? Actually, sir.
Okay. No worries. Your voice is breaking, so okay. Ashish, just tell me the next part.
Sir, regarding the assess the role, it is asked, so sir, we will write ki what is the current role and what are the limitations to the role.
Not current as such, but positives and
negatives.
Negative.
What are the limitations?
Okay. Perfect. Now, how are you going to generate the points? Yes, Tavishi.
Okay. For like positive social justice for poor, like for marginalized communities, for justice, and okay, for positives. Okay, I cannot generate the points exactly.
Okay. Karan. Okay, Karan. Okay, Uday.
Yes, sir. Actually, I'll tell for the negatives. For the positives, I'm going to tell that whatever the people are under the consideration, it is good for them. And for the negative, other underprivileged people who are not being included, the problems which would be they would be facing. Like I think transgenders I don't think are included. All such people who will not be included, I'll be putting that in the negative.
Exclusion. Tell me the points in the positive.
In the positive, like the women and children would be included, which that because most of them are like according to the data they come under below poverty line, at least compared to the men. So
How
so
are you
then
going to?
that's the reason they'll be more supported. Again, the SC/STs, they're also underprivileged. So
That will be the repetition of the points again, because you have already mentioned those sections in the positive side, in the first part, entitlement.
positive, again, it is in convention to other global practices, in line with other global practices. That is also
There are no global practices with respect to free legal aid.
okay.
Okay. Soham, can try. Just give me the framework.
Yes, sir. Sir, in positive, I will write about awareness.
No, on positive side, what will be the framework?
We can use PICE from political.
PICE approach, okay.
Start from legal education.
Okay, so ठीक है. With respect to P, that is again उसमें legal आएगा, constitutional आएगा.
Yes.
Right. So it will be constitutional.
Okay, and
mandate or fulfillment of constitutional mandate under Article 39A.
no,
Then
it also will be Article 14.
नहीं, दूसरा ज्यादा से ज्यादा आप क्या कर सकते हो कि it, this upholding the Article 21 under which access to justice is considered as fundamental right under Article 21. ठीक है, okay. From institutional perspective, okay, Samchita, you can try.
So from institutional perspective, we can try district legal service authority and then
Yes,
state legal
basically,
service authority.
it provides institutional framework. At national level,
We
Chief
have
Justice
NALS.
of India is the patron in chief. Okay, similar, you have state legal service authorities, district legal service authorities. What else?
We also have Lok Adalats. I'm
Yes,
not
so
sure.
it also conducts Lok Adalats for speedy adjudication of the disputes. Okay. What else from economic perspective? It provides the cost effective access to justice. Secondly, it also provides them with the legal representation, right? So free legal representation to prisoners. Okay. Then from social perspective, yes. What will be the point? से इसी में से कुछ from social perspective, what are going to be your points? So from social perspective, yes, legal awareness. ठीक है. And again, role played में कभी भी इकोनॉमिक हो या इंस्टीट्यूशनल हो, उसमें आप हमेशा एक पॉइंट ऐड ही करो कि यूज ऑफ टेक्नोलॉजी टू एनहांस द रीच. ठीक है. यस, हेल्प मार्जिनलाइज कम्युनिटीज और जस्टिस मार्जिनलाइज कम्युनिटीज. और ये क्या है, नालसा? डू यू नो नालसा जजमेंट? हैव वी डन नालसा जजमेंट? व्हाट वाज नालसा जजमेंट? नालसा जजमेंट क्या था? यस, is with respect to transgender, right? So it also participates in through PIL. ठीक है, that. And then issues में again, ये एक चीज याद रखो, जब भी आप ADR का टॉपिक कर रहे हो, अल्टरनेटिव डिस्प्यूट रीएड्रेसल, उसमें हमेशा, ठीक है, स्पीडी जस्टिस, अफोर्डेबल जस्टिस, because of it is informal in nature. ठीक है, speedy, affordable and accessible justice, ये तीन चीजें आपके आनी चाहिए. ठीक है. एंड देन इसके मेजर इश्यूज में अगेन आपके इंस्टीट्यूशनल में लैक ऑफ इंफ्रास्ट्रक्चर, इकोनॉमिक में लैक ऑफ फंडिंग या फिर बजटरी कंस्ट्रेंट्स, सोशल में लैक ऑफ अवेयरनेस. ठीक है. यही आपके पॉइंट्स आएंगे। दूसरा कि इसमें आपको यू रिक्वायर द लॉयर्स, लैक ऑफ ट्रेन्ड lawyers. Okay. And then conclusion, same conclusion you can write. Okay. Now, just to give you the idea with respect to who can receive the legal aid, this may be first the poor who have the income below 5 lakh, sorry, 3 lakh, and 1.5 lakh for Dalits. Then women and children. Okay. Then victims of trafficking, person with disabilities, industrial worksman, and then persons in custody. ये इतने होते हैं, ठीक है? Based upon this, yes, mentally ill, yes, victims of human trafficking also, beggar, ठीक है, beggar also you can mention. इतने. So based upon that, you have to write the answer. ठीक है? So start. You have time till it's 6:34, 6:41. Yes, poor salary also you can mention. 1 लाख नहीं होता है उनको, ऑनम उनको सैलरी नहीं मिलती है बेसिकली, ठीक है, केस बेसिस पे मिलता है, दैट इज ऑल्सो वेरी लेस, 1000 to 1500 फॉर लॉयर्स. देयर वन कीवर्ड यू कैन यूज इज दी प्रो बोनो सर्विस. 9 minutes हो गए. आफ्टर ब्रेनस्टॉर्मिंग इट शुडंट इवन टेक 6 minutes. ठीक है, चलो. सो हु आर entitled to receive free legal aid and assess the role. So free legal aid is a fundamental component of access to justice. It is provided under Article 39A and operationalized through Legal Service Authorities Act. So आपका नालसा जो है, यस, सो करण करेक्ट वही डाला है, ठीक है. सो नालसा इज अ स्टैट्यूटरी बॉडी एस्टेब्लिश्ड अंडर लीगल सर्विस अथॉरिटीज एक्ट. So intro also has to be, or in intro, you should also mention Legal Service Authorities Act. Okay. Then persons, women and children, members, SC/ST, victim, human trafficking, person with disabilities, annual income below prescribed limit, 3 lakh, 1.5 lakh. Okay, so 3 lakh to approach Supreme Court and 1.5 lakh for the district courts. Okay. Guys, cameras, please. Then victims of mass disaster, ethnic violence, flood, etc., and persons in custody. ये रिमेंबर, जस्ट रिमेंबर, अब इस पे तो पूछने वाले हैं नहीं वो क्वेश्चन बाद में, सो दैट्स फाइन. सो रोल इन इंश्योरिंग लीगल एड, ठीक है. फर्स्ट ऑफ ऑल, अगेन while using the PICE framework, so from political perspective is fine, but institutional perspective is कभी भी whenever you are talking about any law, ठीक है, that law provides some kind of the framework. ठीक है, कि जैसे सपोज आपको क्वेश्चन आ गया, असेस द परफॉर्मेंस ऑफ दिस पॉश एक्ट, ठीक है. सो फर्स्ट ऑफ ऑल, along with legal provisions, it also provides the institutional framework or institutional mechanism. जैसे पॉश एक्ट के अंडर आपके पास यू हैव इंटरनल कंप्लेंट्स कमिटी, राइट, या फिर अंडर दिस पॉस्को एक्ट के अंडर यू हैव दी स्पेशल कोर्ट्स और दी चिल्ड्रन कोर्ट्स. सो इंस्टीट्यूशनल आर्किटेक्चर हर एक्ट के अंडर होता ही है, ठीक है. सो इट प्रोवाइडेड इंस्टीट्यूशनल फ्रेमवर्क. CJI as patron in chief of NALSA, and it supervises State Legal Service Authorities Act, District Legal Service Authorities Act, and Taluka Legal Service Authorities Act. Second, from the social perspective, it conducts लोक अदालत्स एंड लिटरेसी कैंप्स, ठीक है, लीगल एड क्लिनिक्स। लिटरेसी कैंप्स तो एटलीस्ट आपका आना चाहिए इन रूरल एंड मार्जिनलाइज्ड एरियाज, ठीक है। अब यहाँ पे अगर आपको पता नहीं है, ठीक है, यू कैन सिंपली जनरेट द एग्जांपल ऑन योर ओन, ठीक है। सो फ्री लीगल एड कैंपेन इन ट्राइबल एरियाज, खुद से बना दो, कोई प्रॉब्लम नहीं है, ठीक है। देन एडीआर ऑर्गेनाइजेस लोक अदालत फॉर स्पीडी लो कॉस्ट डिस्प्यूट रिएड्रेसल, ठीक है। एंड रिमेंबर दिस फैक्ट कि नेशनल लोक अदालत इन 2023 it made a record of solving 1.3 crore cases. There is one important fact with respect to ADR. Then it also started specialized scheme for vulnerable groups. Example, NALSA, enforcement of the, or simply tribal rights scheme. Then free legal representation and counsel. जैसे they provides the lawyer and legal aid in prisons for under trials. Again, person in custody आपका है, ठीक है, तो वो एंड यूज ऑफ टेक्नोलॉजी, ई लोक अदालत फॉर डिजिटल एक्सेस टू जस्टिस इन रिमोट एरियाज, ठीक है। वैसे देन चैलेंजेस अगेन, लो अवेयरनेस, shortage of trained lawyers. Okay, so there was one India Justice report. Remember, on the questions related to ADR, you try to quote India Justice report always. ठीक है, as per it, कि though 80% of the people are eligible, only 15 million used the ADR since 1995. ठीक है, then shortage of trained lawyers. कि lawyers avoid pro bono service due to low honorarium, 1500 to 7500 only. ठीक है, next resource constraint. Resource constraint, India spends only 10.75 per capita annually on legal aid. But not, I think 10.75 भी नहीं है, 0.75 ही है. I'll check and I'll let you know. ठीक है, tomorrow. That an implementation gap, uneven performance across states and districts. हाँ, way forward table also you can give. Way forward ऐसे, या फिर you can make a table issues way forward. नहीं, यहाँ पे way forward table नहीं आएगा. Directive is assess. Assess मतलब 50-50 रहता है, तो उसका positives and challenges, negatives, both will come under the point format. That, so ये डेटा 10 नहीं है, तो ये 0.75 है, ठीक है, 0.75 पर कैपिटा एनुअली, ठीक है, दैट एंड देन वे फॉरवर्ड, ठीक है। तो अब यहाँ पे जो इश्यूज है कि शॉर्टेज ऑफ लॉयर्स आर नॉट don't want to work or they avoid work, then increase or the fair compensation to the lawyers. Then for economic resource, increasing granting aid and resource allocation to NALSA. ठीक है, अगेन लो अवेयरनेस के लिए अवेयरनेस कैंपेन्स वाया रेडियो, टीवी एंड लोकल मीडिया, ठीक है। देन अगेन मैंडेटरी प्रो बोनो वर्क फॉर लॉयर्स, ठीक है। गिविंग वे फॉरवर्ड इज वेरी इजी, जस्ट वॉट एवर इश्यूज आर देयर उसी के करस्पॉन्डिंग वे फॉरवर्ड्स दे दो, ठीक है। यहाँ पे टेबल नहीं आएगा बिकॉज डायरेक्टिव इज एसेस, वी हैव टू गिव 50-50 वेटेज, सो पॉइंट फॉर्मेट में ही आएंगे चैलेंजेस। एंड देन कंक्लूजन, free legal aid is essential to realize the constitutional promise of justice, social, economic, political. कहाँ पे दिया है ये? In preamble. ठीक है. So for ADR, this is the conclusion that you will be using to realize constitutional promise of justice, social, economic, political. Second one that you can use is to then effective ADR is essential to address the principle of justice delayed, और ऐसे कर लो, वो मैंने नेक्स्ट क्वेश्चन में भी किया है, thus effective ADR is essential, ठीक है, to ensure that justice is neither delayed nor denied. ठीक है, this ये क्लियर है with respect to Nalsa. Then next is, I think, just give me a minute. Next question is, okay. So we'll this also done. Okay. So explain the reasons for growth of public interest litigation in India. As a result of it, has the Indian Supreme Court emerged as the world's most powerful judiciary? Okay. So who wants to give me the structure of this? Yes. Article 39A you have already mentioned in introduction, तो अब फिर से देने की जरूरत नहीं है conclusion में भी. Yes. Again, it is a simple. Who wants to give me the structure of this? Okay, good. Swarali, you can unmute.
So initially I'll start with the actual definition is not there of PIL. So SC has given a statement. So that would be as an intro. Then significance of PIL. Then as a result, it has the Indian Supreme Court.
Significance of PIL, will you write into point format or what?
So point format, significance of PIL or a diagram based.
कहाँ पूछा है उन्होंने significance of PIL?
So
So if you want to give, you can give the objectives.
okay.
But वो diagram होंगे.
Okay.
ठीक है, it won't be in point format because वो पूछा
Okay.
नहीं है. ठीक है, it will be like a context. Next.
Then, sir, how Indian Supreme Court has emerged as the world. So, how PIL has helped
No.
this
After the objectives,
uh,
read the question again. What is the first demand of the question?
growth of public interest, PIL, growth of PIL,
Reasons.
reasons for the growth of PIL.
Okay. Next.
Then, as a result, so then how has Supreme Court through PIL has emerged the most powerful?
Okay. How SC has
With the
become
help of PIL has emerged one of the most powerful weapon of
ठीक है.
judiciary.
Okay. Then
So can we write challenges or is it?
नहीं.
नहीं.
Okay. चलो कोई बात नहीं. यहाँ तक तो सही है. Next वाला थोड़ा सा. Yeah. Okay. Sana, you can unmute. Okay. नहीं कहा गया. Swayam, you can unmute. Yes.
Hello, sir.
Yes.
In the last part, how SC has become, that part it has asked in the question that has the Indian Supreme Court emerged as. So here we can do as a argument, like argument in favor and
Yes.
argument against.
So basically, this is your opinion-based question.
Yeah.
It has it emerged as the most powerful. So they are asking as the opinion, right? So while
Opinion.
giving the opinion, which rule you use? 60-40,
60-40.
where basically you give the arguments in favor that
And
yes,
argument
Supreme Court
against.
has emerged as most powerful, and no, there are still challenges. Okay. So reasons: SC as most powerful, yes, no. Okay. And then way forward. Okay. Then how are you going to generate the points in the reasons? Okay, who wants to try? Vikash?
Sir, we can use the Supreme Court judgments in like Husnaira Khatun case and the SP Gupta cases to justify the reasons.
No. Those are the cases. Those will be used in yes aspect, how it has emerged as the most powerful. We want the reasons why it has emerged. Oh, sorry, why PIL or why there is a growth of PIL.
So currently, I can't think of any.
ठीक है, okay. Arvinda, you can unmute.
Yes, sir. We can use SPICE approach.
Yes.
In political point, we can use democratizes judicial process.
Okay. That
In
will come into
institutional,
social.
okay. In institutional, we can give expanding Article 32 and
Constitution.
okay.
Okay. So from these perspectives, you can generate the points. So from judicial perspective, it was judicial activism.
Yes.
Okay. Then post emergency. Okay. So during the context is during the time of emergency, the judiciary was criticized, right?
Yes.
For that ADM Jabalpur case. So
Yes.
after the emergency, they tried to adopt the judicial activism through the
Yes, sir.
PIL. So first case was filed in, or first case that was accepted as a PIL was by Justice Krishna Iyer in 1976.
Yes, sir.
Okay, that. Then judicial activism is there. So from judiciary perspective, again,
Empowering the judiciary.
yes, the role of judges. Okay, third, global trend of the social interest litigation of the
Practicing,
US.
yes.
So from the perspective of executive, yes, executive,
Brings governance accountability.
no, executive overreach.
Yes.
In ensuring government accountability is the function of PIL.
Yes.
Rise behind PIL is the executive overreach.
Okay.
Okay, so PIL has also been used to put stay on the government projects.
Okay.
Right. With respect to legislature, to fill legislative vacuum. Right. कल ही हमने किया ना, parliament is on a decline.
Yes.
If parliament is on decline, someone has to fill the legislative vacuum.
Yes.
Who filled that legislative vacuum? Judiciary through PIL.
Yes.
What is the example of it? अभी हमने पहले किया है. Visakha guidelines.
Yes.
Right. So Parliament failed to make a law on the sexual harassment at workplace. So judiciary came forward and framed the Visakha guidelines.
Legislative framework.
Then from the citizens perspective, again, जो पिछले ADR में भी हमने कहा था, access to
justice
to marginalized section. This has been done by this liberalizing the principle of locus standi.
Standing.
ठीक है. Then civil society, who files the PIL cases? Mostly
NGOs.
civil society or
Civil
the
society
NGOs.
organizations.
So civil society activism.
Can we name civil society organizations?
Yes,
PUCR.
Yes, इसी में you can classify the points like political activism like ADR. So you have the judgment of ADR. Environmental activism, you have MC Mehta cases.
Yes.
Social activism, the Sabrimala
PUCR.
verdict.
Okay.
Sabrimala was basically with respect to young Indian Lawyers
Association versus State of
Okay.
Kerala.
Yes, that. Second, you have NALSA.
Yes. And PUCR for that child.
वो भी
Married
कर
to
सकते हैं, बचपन बचाओ आंदोलन जजमेंट,
yes,
that
yes.
also you can add. And constitution again,
Expanding Article 32.
yes, expanding article
32.
21.
Oh, yes.
Article 21, you can give Husseina Khatun case, you can give Ogla Telly's case, वो सारे. So this is the reason
Yes.
based upon the stakeholders.
Yes.
Okay, then as a reason, has Supreme Court become the most powerful? Okay, so arguments in favor. Yes. How will you generate the points on justification? Yes, Swayam, you can unmute, turn on your camera and tell me the points.
Sir, we can do like constitutional provisions are there.
So basically,
Like
yes,
Article 141, then Article 142.
yes. So use
Judicial
of
review.
Article 141, 142. Second, expanding the judicial review powers. ठीक है, जैसे एग्जाम्पल आपका कौन सा इसमें आएगा कि इंट्रोडक्शन ऑफ ड्यू प्रोसेस ऑफ लॉ,
Wow.
राइट, अंडर
Yeah.
आर्टिकल 21. ठीक है, व्हाट एल्स?
Sir, institutional we can write like judicial activism in favor.
तो जुडिशियल एक्टिविज्म मतलब कैसे? सुओ मोटो कॉग्निशंस, ठीक है, सुप्रीम कोर्ट इज टेकिंग सुओ मोटो, सुप्रीम कोर्ट इटसेल्फ इज फाइलिंग द पीआईएल. ठीक है, व्हाट एल्स? वही ना, थिंक फ्रॉम द पर्सपेक्टिव फॉर स्टेक होल्डर्स. सो check on executive. Example, ban on firecrackers. So if judiciary is keeping check on executive, accountability of executive, then check on legislature, NJSC judgment, same.
Yes, sir.
ठीक है, so it has made the Supreme Court more powerful than these two, right? Then
Yes, sir.
preserving judicial independence. ठीक है, एनजेएससी हमने वहां पे दे दिया, तो इंडिपेंडेंस का नहीं आएगा. व्हाट एल्स? How it has become the more powerful? वही लिखो ना, expanding fundamental rights. Right, so expanding fundamental rights also checks legislature and executive. Example, right to privacy. So right to privacy में आधार का आपका sections invalidate किए कि नहीं? तो again expansion of the fundamental rights under Article 21 has made Supreme Court more powerful than other organs. ठीक है, वो नो में कौन से पॉइंट्स आएंगे या फिर challenges basically? So there will be the same challenges like dependency of cases with respect to PIL, the fake or frivolous PILs, right? Fake, yeah, or PIL turning into private interest litigation. ठीक है, pendency मतलब burdening of judiciary. Then criticism as judicial overreach. ठीक है, एग्जाम्पल बैन ऑन फायर क्रैकर्स वाला जो हम यूज करते हैं, या फिर ऑड इवन पॉलिसी वाला, या फिर सुप्रीम कोर्ट दिस क्या कहते हैं, कोल एलोकेशन वाला, इनवैलिडेटिंग द कोल एलोकेशन इन 2G केस, या फिर सुप्रीम कोर्ट बैनिंग द डीजल व्हीकल्स इन दिल्ली, that is also the case of judicial overreach. Yes, BS4 vehicles also. ठीक है, देन जुडिशियल ओवररीच से ही आपका पॉइंट आएगा अंडरमाइंस सेपरेशन ऑफ पावर, राइट, लीडिंग टू पॉलिसी पैरालिसिस. ठीक है, व्हाट एल्स? सो लैक ऑफ एनफोर्समेंट. ठीक है, सो इवन इफ जुडिशरी गिव्स द जजमेंट, इट लीड्स टू लैक ऑफ एनफोर्समेंट. ठीक है, दोज, तो ये आपके उसमें पॉइंट्स आएंगे. एंड देन यू गिव द वे फॉरवर्ड कि जुडिशियल गाइडलाइंस टू प्रिवेंट फेक एंड पेनल्टी फॉर फेक और फ्रिवलस PILs, उन पे पेनल्टी लगा लो. व्हाट एल्स? रिस्पेक्टिंग separation of power through judicial restraint, right? इन्हीं के दे दो ना. So judicial overreach and separation of power के क्या? Judicial restraint. So lack of enforcement में ensuring monitoring mechanism to ensure enforcement of the Supreme Court orders. Okay. And then conclusion, same Lord Bryce wala. Right? This PIL पे next year also you can get a question. ये clear है? How you have to brainstorm using these stakeholders. ठीक है, so remember these stakeholders. ADR में भी आप ये use कर सकते हो. PIL में तो करना ही है. ठीक है, कंटेम्प्ट ऑफ कोर्ट में भी यही यूज करना है. ओके, सो do you want to write this particular answer or shall I dictate? 15 marker है. Yes, do you want to write or shall I dictate? You can write, dictate, right? Okay, so start. Next one I will take second. Next one I will dictate. So it's 7:10. You have 7:22. Yes, Rohit.
Sir, in the no section where we write that judiciary has not become the all powerful, we wrote a point of judicial overreach. That's the power of judiciary that has emerged through PIL, not the limitation.
It is not the limitation. It is we are writing in a way it has been subject to criticism as a judicial overreach.
Criticism of judicial overreach could be the point, or institutional strengthening or public awareness, media. This could be the agents to check the judicial are still alive to check the judicial power.
No, where they have checked? Who had checked the judicial power?
Public, like protest against dog sanitation case. Public, one example is there. And continuous criticism by law minister of.
फर्क क्या पड़ा है? What difference has it made? Nothing. And secondly, again, that is the check on the judicial power. तो वही arguments against ही आएगा आपका. Criticism as judicial overreach. No, so that criticism hasn't made judiciary most powerful.
Okay.
I see.
Instead of points, I was thinking of writing in paragraph. Maybe
You
that
will
is
get
still
two less marks.
Okay.
Remember this rule. Okay, just give 20 seconds to me. So just remember this rule. Your copy in the actual examination is going to be checked in maximum of 20 minutes. उनको 1000 कॉपी चेक करनी होती है, तो वो एक कॉपी को वो जैसे नॉर्मल इवेल्युएशन दैट वी डू, it takes around 1 to 1.5 hour if you have written all the 20 questions. But in actual UPSC जो आपके कॉपी चेक होने वाले हैं, that is going to be checked in maximum of 20 minutes. अगर आप रविंद्रन सर से बात किए होते, आप में से किसी ने, लेट रविंद्रन सर, he told us that it is checked in maximum of 10 minutes because they have zero accountability. आपको कोई जेरोक्स कॉपी नहीं मिलता है, वो कोई नहीं चेक करता है आपको मार्क्स कहाँ पे मिले हैं, कैसे मिले हैं. दे हैव जीरो अकाउंटेबिलिटी, उनको कोई लेना देना नहीं है, वो कुछ भी मार्क्स आपको दे सकते हैं. ठीक है. सो दे हैव जीरो अकाउंटेबिलिटी. सो इट्स योर जॉब टू नॉट इरिटेट द इवेलुएटर एंड टू मेक हिज जॉब इजियर. तो जितना आप अंडरलाइनिंग कीवर्ड्स पे करोगे, जितना आपके की पॉइंट्स की विजिबिलिटी रखोगे, दैट इज राइटिंग इनटू बॉक्स और गिविंग द कोलन, उतना उनके लिए काम आसान होता है. यू मेक हिज जॉब इजियर, he will give you more marks. आप पैराग्राफ में लिखो, आप अंडरलाइन मत करो, he has to read everything and he will get irritated. ठीक है. So don't think about writing into paragraph. Okay, continue. 7:22 तक आपको लिखना है. लास्ट मिनट हो गया. वसुंधरा स्वराली फिनिश. तीनों पेजेस हो गए. गुड. पीयूष. ओके चलो. So introduction, if you see, what I have done is I have gone with the definitional introduction. ठीक है. So PIL is a judicial mechanism that allows any, just remember this keyword, public spirited individual, ठीक है, or organization to approach court on behalf of others for enforcement of fundamental all legal rights. Basically, public interest litigation is, in normal litigation, what happens is the victim goes to the court. ठीक है, कि suppose any injustice has happened to you, you approach the court. But in PIL, somebody else approach on behalf of you. For example, the tribal people, they can't go to the court because of lack of awareness, accessibility, affordability, or whatever reasons. So on their behalf, a public spirited individual or organization, basically that is NGO or any individuals like the Kailas Satyarthi, etc. Okay, so they go to the court to enforce, so they go on behalf of others to enforce fundamental or legal rights. Okay, so this is the definition. It evolved in India as a tool of social action litigation, expanding the reach of justice under Article 32 to 26. Okay, so this is one introduction, which is definition. Okay, second is you can go with the historical introduction. Okay, what will be the historical introduction? मैंने अभी कहा था, ठीक है, कि the PIL in India is inspired from social interest litigation of the US Federal Court. ठीक है, and it was institutionalized in India by judges like Krishna Iyer and Justice P.N. Bhagwati. Okay, this can be your alternate introduction, which is the historical introduction. ठीक है, अगेन मैंने आपको आई थिंक कितने 6 फॉर्मेट्स दिए हैं by which you can introduce the answer. So during the course of writing 600 answers, अगर 7th कोई framework आपको मिले तो मुझे बता देना. ठीक है, I won't launch this batch next year. ठीक है. So the second one is the historical also you can give, is the inspired from the social interest litigation of the US and institutionalized by Justice Krishna Iyer and P.N. Bhagwati. Then you briefly give objectives of the PIL with the diagram. Objective is accessibility, government accountability, judicial oversight, or rule of law and balance. Ever simply rule of law लिखो. ठीक है. That again it is based upon the stakeholder. This is for citizens. This is for executive. This is from the perspective of judiciary. This is from the perspective of constitution. ठीक है. Then reasons for growth. Again कभी भी जब आपको reasons पूछते हैं, जैसे मैंने कल भी I think in one of the answer also we talked about the historical reasons, right? So historical factors. Post colonial India witnessed deep social inequality and poverty, and PIL emerged as a tool for social transformation and distributive justice. ठीक है. या फिर you can also give a quote which we used in previous questions कि इंडियन जवाहरलाल नेहरू का quote कि Indian constitution envisions actively fierce judiciary as a part of social revolution, and PIL is the pillar of that vision. ठीक है. Then liberalization of locus standi, shift from personally aggravated to any public spirited citizens can file case. Then from perspective of judiciary, judicial activism post emergency, judiciary asserted as guardian of fundamental rights. वही keyword है same. Example, Justice Krishna Iyer first introduced PIL in Mumbai कामगार केस. ठीक है. अगर केस भी याद नहीं है तो जस्ट रिमेंबर कि फर्स्ट केस वाज इंस्टीट्यूशनलाइज्ड बाय जस्टिस कृष्णा अय्यर इन 1976. 75 में आपका इमरजेंसी था, so it was institutionalized in 76. Then second stakeholder is parliament. So decline of parliament. So decline of parliament, legislative inefficiency and lack of responsiveness to social issues. So because of that, judicial activism emerged. Example, Visakha guidelines. Right. Then third stakeholder is civil society. So rise of civil society activism. So growth of NGO, media, human rights groups used to advance social, human rights, environmental causes. Example, Bandhan Mukti Morcha judgment, right to livelihood. You can also get MC में था, या फिर आप कैसे कर सकते थे इसको कि rise of civil society, political, example, EDR on political corruption, social, example, Sabrimala, environmental, example, MC Metha cases. ठीक है, ये सारे केसेस वही रिपीट कर रहे हैं हम. ठीक है. देन from the perspective of executive, it is executive outreach and inaction, right? So bureaucratic corruption and maladministration, policy failures prompted judiciary to step in as a corrective mechanism. Example, Vinit Narayan judgment on CBI accountability. Again, ये केस भी हमने पहले ही किया है, not the new one. Then global factors, key comparative judicial trends. Example, USPIL, और वहां पे सोशल इंटरेस्ट लिटिगेशन बोलते हैं, USSIL. ठीक है. देन कॉन्स्टिट्यूशन, कॉन्स्टिट्यूशनल पावर्स एंड डिजाइन. सो DPSP provided moral backing or moral authority to judiciary, right? And then expansion of fundamental rights, broad interpretation of Article 21 by courts, right to livelihood, education, health, clean environment. ओगला टेलिस MC में था. Again, the judgments are same. Even the points. अब इसमें से बताओ. All the points were generated based upon the stakeholders only. Right. Even the keywords are also same. Keywords भी कोई नए नहीं है. ठीक है. So इंडियन HC ये हो गया. यहाँ तक कोई डाउट? क्लियर है? जस्ट थम्स अप कर दो. ठीक है. ओके. Then Indian SC has the world's most popular, powerful judiciary arguments in favor. Then it has increased judicial review power under 1332 to 26. Example, NJAC case. Okay. Then Supreme Court also talked about suo moto jurisdiction. Okay. It has also led to suo moto jurisdiction. Example, cognizance of COVID-19 migrant crisis. Supreme Court took suo moto cognizance of COVID-19 migration. Then this, the next important, just a second. So it is epistolary or jurisdiction. So epistolary jurisdiction basically means it is also liberalization of locus standi. Under it, even the letters sent, normally PIL में क्या होता है? Public spirited individual या organization आता है. But even anonymous letter were also accepted by judiciary. That is called as epistolary jurisdiction. ये एक नया point है. Just add this keyword कि allows letters, postcard as petitions. ठीक है. So widening access to justice. इसका केस नहीं लिखा तो भी चलेगा. सुनील बत्रा केस है. नहीं लिखा तो भी चलेगा. That's fine. Even this keyword will suffice, which is your X factor. Then again, expansion of fundamental rights. So Puttaswamy case, right to privacy recognized as fundamental rights. Then judicial oversight on policy, so which made judiciary as the supreme. Again, Visaga guidelines. Legislative powers under Article 141. Take example, SC judgments on governor's veto power, the recent. Okay. Then again, moral and institutional legitimacy. Example, Navtej Singh Johar. So these all factors highlight towards the judicial supremacy. And under it, if you want, you can give one view of the scholar ki according to Bhikkhu Parekh. He was the MP. He is actually a multiculturalist scholar. He was MP in the UK. So according to Bhikkhu Parekh, India is the classical case of judicial governance. Okay, so rather than, what he meant to say is, rather than constitutional supremacy, we have judicial supremacy. Because according to him, India is the classical case of judicial governance. ये एक आप simply scholar view, as a scholar view you can put. Then arguments against judicial overreach, encroachment upon the executive and legislative domains. Example, ban on firecrackers. Right. Then you have weak enforcement capacity. जो हमने पिछले में भी लिखा था कि प्रकाश सिंह police reforms, non-compliance by most states. Then frivolous PILs, increased pendency, more than 5 crore cases pending. Then lack of judicial accountability, जो recent आपका case है, that highlights lack of judicial accountability. Then opaque collegium system, uncle judge syndrome, inconsistency and selective intervention, so uneven response in bail cases. Okay, example, if you want to give Umar Khalid case, you can give as the example, right? Then frequent judicial intrusion weakens separation of power. Again देखोगे तो वही points. Again, then you give the way forward. Judicial restraint या फिर institutional restraint, scrutiny of the PIL, then to ensure the enforcement, monitoring mechanism. Okay. Then constitutional literacy. Again, this is one of your keyword, to promote responsible use of judicial remedies by citizens. And then last is dedicated PIL cells in high courts. Okay. And then this is your fourth quote for judiciary. As Justice J.S. Verma cautioned, तो जब भी जुडिशियल ओवररीच या फिर ऐसे थीम्स पे आप लिखते हो, यू हैव टू राइट एज जस्टिस J.S. वर्मा caution, judicial activism must not become judicial overreach. ठीक है, उसके आगे 10 effective safeguard against PIL are essential. इतना ही लिखो. ठीक है, 10 चलेगा. Then next is, this is about the PIL. Similar question you have on growth on public interest litigation. Same question on the PIL that you had was this one. Yes. Judicial legislation is antithetical to doctrine of separation of powers as envisioned under the Indian Constitution. In this context, justify filing a large number of PIL, praying for issuing guidelines to executive authorities. Okay. So who wants to try the structure of this particular answer? Yes. Read it twice before trying. I just need the structure. Then we'll talk about the brave dimensions. Yes. Okay. Kushi.
Yes, sir. So, antithetical to doctrine of separation of powers, can we talk about how judicial legislation is a threat to separation of powers? Production.
Yes.
Okay, and then we can draw maybe a brief flowchart about the separation of powers in the Indian Constitution.
Okay, what will be the introduction? Tell me.
Can we define judicial legislation in terms of judicial activism?
It is not judicial activism, but you can define judicial legislation. Yes.
Okay, proactive role of judiciary in filling legislative vacuum, maybe. Okay.
Then next.
Context. Filing large number of PIL. In the PIL case, can we talk about the positives and
after this, what will be your heading?
Heading? Separation of powers.
Okay.
In the Indian Constitution.
Next.
And then the next heading can be the increasing number of PIL filed.
Okay.
Under that, yeah, we will justify it on one end, and then the second would be the issues with it.
Okay.
And then maybe way forward.
And conclusion. Okay. Who else want to try? One thing is missing. Yes, Sana, you can unmute.
Hello, sir.
Yes.
First, with any introduction with any quote,
Okay.
or the definition of judicial legislation, or can connect with the PIL.
Okay.
The first heading should be judicial legislation is antithetical to doctrine of separation of power. मतलब how judicial legislation is antithetical. मतलब that's I want to say. Antithetical to a doctrine of separation of power.
Okay.
The second will be the part कि how PIL is using by Supreme Court to execute the authorities.
So basically what you have to give. See, there are 4 things to analysis of anything. Either its significance or its issues with it. ठीक है, या फिर इसके फीचर्स, या फिर उसके रिलेटेड वे फॉरवर्ड। इन चारों में से क्या लिखना है, यही 4 में से एक होता है कभी भी। So in this context, justify filing large number of PIL.
Both significance and issues combinedly.
नहीं, what they are asking, justify.
Justify.
ठीक है, they are asking assess filing large number of PIL. If they would have asked assess filing large number of PIL, then obviously 50-50 आ जाता कि where significance which is justification and issues आप बता देते। बट यहाँ पे आपको क्या क्लियरली बोला है कि justify filing large number of PIL means what you have to highlight, significance 70% आपका इसी को जाएगा, राइट ऐसे। ठीक है, यस। उसके बाद justification and at the end issues and way forward in table, right? Okay, now how are you going to justify the filing large number of PILs?
So no point is sitting in my mind right now.
Okay, no worries. Rohit?
Sir, we have to justify in respect to
Tell me
weakening
framework.
sir. We are thinking about executive authorities. So weakening of executive authorities के functions जो weaken हो रहे हैं executive authorities के, और एक point में उसमें cases, we can use cases about where executive authorities have functioned.
एग्जीक्यूटिव एक हो गया, उसके अलावा
सर suo motu cognizance, because
justification कैसे है?
negligence, because the executive authorities are neglecting various social problems. That's why judiciary has to take a suo motu cognizance.
Okay.
And fast delivery of justice, because in cases like Vishaka guidelines, judiciary cannot wait for the authorities to react.
Yes.
So,
ठीक है. Okay. Tavishi, you can try last. Yes.
So we can use the same stakeholder approach as we used in the
Yes.
previous question.
Stakeholder approach, यही points आएंगे आपके.
Yes.
In justification, the same.
Yeah, judiciary, legislative, executive, citizens, civil society.
So justification क्या आएगा आपका कि civil की basically you have to highlight the significance of PIL.
Yes.
Or access to justice to the marginalized. ठीक है. Then civil society activism, ensuring government accountability, filling the legislative vacuum, fulfilling
over executive overreach.
Yes, fulfilling the constitutional mandate. ठीक है. The Supreme Court's role as the guardian of the fundamental rights of the citizens.
Liberalization of
Then
local standing.
in line with the global trend with respect to the expansion of fundamental rights of citizen, example right to privacy, right? So वही points आपको बस थोड़ा सा rephrase करना है कि जैसे rather than writing this कि judicial activism, what you will be writing कि Supreme Court role as guardian of the fundamental rights of citizens. Rather than writing declining of the parliament, you will write to fill the legislative gap. Example, Visakha guidelines. Rather than writing civil society, rise of civil society activism, to complement the rising civil society activism. Then rather than executive overreach, to check the executive overreach, which is the justification of the PL. Right. So on that lines, you have to write the points. ठीक है, उसके issues same, way forward same. Now one more aspect is कि how judicial legislation is antithetical to the separation of power. How are you going to generate the points under this?
Judicial overreach, so first of all.
What else?
Judicial activism or overreach, maybe I'm not sure if there should be two separate points or in this same we can write.
No, they are separate. Activism is generally taken in the positive sense.
Yeah.
Yes, judicial overreach, it again creates or undermines
Separation of power.
democratic accountability. Because judiciary is not accountable to the people, unlike the executives. So unlike the representatives, MP, MLAs, judiciary is not accountable to the people. Right. Why then Bhikkhu Parekh, India is the classical case of judicial governance, where judiciary gets primacy over the other organs of the state. ठीक है वो then Supreme Court itself has warned against the overreach in two of the cases. वो points आएंगे, then it will be justification, then issues way forward. ठीक है, so I'm dictating this answer, you guys just yes, encroaching legislative domain, good, that point will also come. So I'm just dictating this, you just note it down. Introduction, you can define the judicial legislation. Yeah, so judicial legislation is or refers to judiciary making laws and framing policies and is considered as antithetical to separation of power. ठीक है, according to Bhikkhu Parekh, India is the classical case of, in colon, write it into the capitals, judicial governance. ठीक है, then judicial legislation antithetical to separation of power. First, encroachment on legislative domain. ठीक है, second, undermines democratic accountability. ठीक है, as judges are unelected. Example, ban on firecrackers. Then judicial overreach and judicial supremacy. It weakens checks and balance. Example, NJSC verdict. Then leads to undermining of executive. Okay. And policy paralysis. Okay. Example, ban on diesel vehicles in Delhi NCR. Then judiciary itself has warned against judicial overreach. ठीक है, एग्जाम्पल वही लास्ट का कोट दे दो, जस्टिस JS वर्मा वाला, जुडिशियल एक्टिविज्म इज टर्निंग इनटू जुडिशियल ओवररीच और जुडिशियल एडवेंचरिज्म. ठीक है, या फिर इफ यू वांट दी जजमेंट्स, स्पेसिफिक जजमेंट्स, देन इट इज अरोली गोल्फ क्लब, ठीक है, वर्सेस चेंडेर, हस, CHANDER HASS. कोर्ट वार्नड अगेंस्ट जुडिशियल एडवेंचरिज्म. जजमेंट नहीं दिया तो भी चलेगा, जो जस्टिस JS वर्मा का कोर्ट है दैट विल आल्सो डू. ठीक है, सो दीज आर योर पॉइंट्स ऑन दी undermining of separation of power. And then justification for filing large number of PILs. इसके पॉइंट्स आपके वही रहेंगे. ठीक है, दैट आई वोंट बी डिक्टेटिंग, यू कैन राइट दोस. And issues way forward will also remain same. And the conclusion, right, this is specifically for the PIL. One conclusion is the previous one. This ki Justice JS Verma quote. The second ki PILs represent participatory constitutionalism. Again, constitutionalism हमारा quote है. We have just linked it with the or given the keyword participatory keyword. No, so it, PIL represent participatory constitutionalism. ठीक है, balance of activism and restraint is needed to ensure justice, to ensure that justice remains. Just make a triangle as a triangle. Just make a triangle and like this. So just a second. To ensure that justice remains accessible, fair, and rights oriented. Okay, this is the conclusion which that AR6 last year, Srishti Dabas in 2023, she used to use this kind of the triangle in conclusions. ठीक है, that ये clear है? Yeah, only first part. Second and third part is going to be same. Again, अगर आपने ये कौन से साल का क्वेश्चन है? This is from the year. Okay, 2020. चलेगा. Now coming to the topic of the tribunals. Okay, we'll do one question on the tribunal. Then, so how far do you agree with the view that tribunals curtail the jurisdiction of ordinary courts? In view of the above, discuss constitutional validity and competency of tribunals in India. Okay. अब ये थोड़ा सा complicated है. Just read it one more time and give me the structure of it. Okay. Who wants to try structure? I just need intro and headings. Whatever, 3, 4, 5. Okay. Kushi?
Yes, sir. So can we, introduction, can it be about the article that has to do with administrative tribunals or tribunals for that matter?
Okay. What is that
Article
article?
323A, is it?
323A, B both.
A, B both. Okay, A is about administrative tribunals.
But then
Okay.
what will you write in constitutional validity? In main body.
In the main body.
Again, that will be the same. Okay, you can start with article
Maybe
320.
in the introduction we can only mention about the article and not
Yes.
go a lot into detail so that we can leave the rest for constitutional validity.
Okay. Next.
Okay. And then how far do you agree? So can we follow 60-40?
Yes.
Okay, then tribunals curtail the jurisdiction of ordinary courts. 60% of yes, how they curtail the jurisdiction of ordinary courts. 40%
But
of
do they
how they
curtail?
do they curtail. I think we will have to give both sides.
So here they don't curtail. So majority of that 60% will go to that. Okay. And
Okay.
again, there are no dimensions, just one point that there is just one judgment. L. Chandra Kumar case, where Supreme
Okay.
Court has held that the appeals against the tribunals will lie with high courts. That's it. That's just the one point you have. Okay.
Okay. And then constitutional validity and competency of tribunals. That will be another heading. Under that, we can.
So it will be single heading, no?
Yeah, single heading.
Okay. Okay. Then after this, I just need the heading. I don't need the points.
Then way forward, but I'm wondering what we will write in way forward.
No, I'll give you the points. It will be the same way forward for all the tribunals and then conclusion. Okay.
Okay.
Okay. Who else wants to try? Yes, Tavishi.
So actually, we can divide the points into two, like constitutional validity and for competency.
Yes.
So yeah, right now I don't know the points, but yeah.
No, that's fine. Yeah. So what will be the, what do you think will come under the validity?
Like constitutional validity means like articles 323 and 323B. Yeah, and for competency,
Legal
maybe,
laws also you can mention.
yeah, okay.
Okay. Yes. Competency में? Yes, who wants to tell me how you are going to generate the points in competency? Yes, Ashish.
Sir, competency में we can divide it by expert matters and
No. Okay, अंकुश. सिंपल है, बहुत सिंपल है. Competency मतलब क्या?
Basically, legal and technical experts are there, and we have
What does
tribunal.
that means?
So that means that they have a defined jurisdiction for a particular matter.
Basically, competency means you have to give them their powers and functions.
Like National Company Law Tribunals.
Powers and functions. That's it. So their competency means what? Basically, their jurisdiction. So they have the powers of civil court under which they can summon, etc. Okay. Then appeal against them lies with the High Court. Then they can issue the final or the binding judgments. Okay. Then their jurisdiction is fixed by the law, because tribunals are made by the law only. Okay. That is their competence, and at the end you give the way forward. Okay. Now, as far as tribunals are concerned, just remember the objectives of the tribunal. Okay. Based upon the objectives only, you can generate the points. So basically, the objectives of the tribunal include: one is specialized justice. Okay. Specialized justice as in the members of that particular tribunal. Okay. They are not just the judicial members. So members include judicial plus specialists. तो जैसे अब आपका कैट हो गया, सेंट्रल एडमिनिस्ट्रेटिव ट्रिब्यूनल, सो इट विल हैव द मेंबर्स बोथ फ्रॉम जुडिशरी प्लस द आईएएस ऑफिसर्स, या फिर जो भी कॉम्पिटेंट होंगे. एनजीटी में दे कैन हैव द एनवायरमेंटलिस्ट. ठीक है. सेकंड, फ्लेक्सिबिलिटी, that is they are not bound by any evidence act or any those acts. They follow the principles of
natural justice.
ठीक है. Third, to burden or lessen the burden on the judiciary. ठीक है. Their primary purpose is this. ठीक है. Fourth, the speedy justice. ठीक है. Fifth, Article 39A, that is to provide access to justice. So accessibility हो गया, affordability हो गया, to provide the cost effective justice. ठीक है. इसी बेसिस पे you can generate or write the answers on any tribunals. Second is इसके major issue समझो. बाकी तो ठीक है, you simply use the PIES approach, तो जो normal judiciary के, but one important is it goes against the principle of separation of power. How? Because they see normally tribunals are not the part of judiciary. Okay, normally Supreme Court exercises the supervisory jurisdiction on high courts and the lower courts, but the tribunals, the administrative control of the tribunal is under line ministry. लाइन मिनिस्ट्री मतलब कि जैसे आपका कैट है, सेंट्रल एडमिनिस्ट्रेटिव ट्रिब्यूनल्स, इट डील्स विथ सेंट्रल गवर्नमेंट एम्प्लॉई, सो इट वर्क्स अंडर डीओपीटी. ठीक है. सो कैट के जो भी ऑफिसर्स होंगे वो डीओपीटी के ऑफिसर्स में होंगे. ठीक है. सिमिलरली एनजीटी विल बी एडमिनिस्ट्रेटिवली कंट्रोल्ड बाय मिनिस्ट्री ऑफ एनवायरमेंट. ठीक है. सो देयर एडमिनिस्ट्रेटिव कंट्रोल लाइज विथ मिनिस्ट्री. And that goes against separation of power because their function is the adjudication, judicial function, but they are controlled by executive. ठीक है. बाकी वो आपके वही आएंगे, वैकेंसीज, पेंडेंसी ऑफ केसेस. ठीक है. वैकेंसी in majority of the tribunals it is more than 50% of the vacancy. ठीक है. पेंडेंसी, then high appeal, वही आपके पॉइंट्स आएंगे. ठीक है. बट ये इंपॉर्टेंट कंसेप्चुअल अंडरस्टैंडिंग यू नीड टू हैव. ठीक है। नेक्स्ट, इसके रिलेटेड विथ रिस्पेक्ट टू देयर जुरिस्डिक्शन। ठीक है। सो बेसिकली कैसे होता है कि दे आर क्रिएटेड अंडर आर्टिकल 323। ठीक है। सो आर्टिकल 323 ए एंड बी। ए के अंडर यू हैव एडमिनिस्ट्रेटिव ट्रिब्यूनल विच आर कैट एंड स्टेट लेवल पे सेट, राइट। एंड यहाँ पे अदर मैटर्स, तो इसके अंडर कोई भी होता है, एनजीटी वगैरह। सो बेसिकली व्हाट दिस डज इज आर्टिकल 323 it gives power to parliament to create the tribunals for any matter. ठीक है। that means all the tribunals are statutory bodies. ठीक है। that means उनका जो भी jurisdiction होगा या फिर उनके जो भी functions होंगे, they will be determined by that particular specific act of the parliament. ठीक है। ये कंसेप्चुअल क्लियरिटी आ गई अब विथ रिस्पेक्ट टू ट्रिब्यूनल्स। ठीक है। बाकी फिर कोई भी ट्रिब्यूनल पूछने दो, एनजीटी वगैरह। ठीक है। वैसे बेस्ड अपॉन दैट यू हैव टू जनरेट द पॉइंट्स। ठीक है। नॉर्मली ट्रिब्यूनल्स आर ओनली फॉर द दिस दिस सिविल केसेस, नॉट द क्रिमिनल केसेस। ठीक है। सो बेस्ड अपॉन दैट यू हैव टू, आई विल डिक्टेट, यू जस्ट राइट दिस आंसर. How far do you agree with the view that tribunals curtail jurisdiction of ordinary? ठीक है. So introduction. Tribunals are the quasi-judicial bodies established to deliver specialized, speedy, and cost-effective justice in specific matters like taxation, service disputes, environment, etc. ठीक है. Remember this keyword. They are the quasi-judicial bodies. Then objectives, जो अभी मैंने बताया, स्पीडी एडजुडिकेशन, स्पीडी जस्टिस, सॉरी स्पेशलाइज एडजुडिकेशन, स्पीडी जस्टिस. देन यू हैव रिड्यूस्ड बर्डन ऑन कोर्ट्स, कॉस्ट इफेक्टिवनेस, एक्सेसिबिलिटी टू जस्टिस. यहाँ पे यू कैन मेंशन आर्टिकल 39A. देन simplified process, that is principle of natural justice. You can also mention flexibility. Effective enforcement of rights. ठीक है. Then tribunals curtailing the jurisdiction. So first, there is a constitutional provision that under Article 323A and 323B permit exclusion of High Court writ powers in tribunal matters. ठीक है. जैसे आपके आर्टिकल 262 एंड 263 के अंडर भी है. Under 262, it has been provided that Parliament can exclude the jurisdiction of the courts in matters of interstate river water dispute tribunals. Right. But Supreme Court in L. Chandrakumar case, what SCA has held that the appeal against the judgments of the tribunals will lie in front of High Courts. Okay. So just remember this case, Chandrakumar. Then second, curtailing jurisdiction of ordinary courts in executive control over appointments of tribunal members. जैसे मैंने कहा कि administrative control is in the hand of line ministry. ठीक है. Then creates parallel judicial system. On the one hand, you have the normal courts, parallelly you are having the tribunals. इतनी इसके criticism. However, in L. Chandrakumar case, SC struck down exclusion of High Court jurisdiction as unconstitutional, reaffirming judicial review as part of basic structure. ठीक है. This. And then अब इसमें इतना ही है, कुछ पॉइंट्स आपके नहीं आएंगे. This is it. You just have to stretch your answer. कुछ फैक्ट्स नहीं है इसमें. Just these facts you remember. And then constitutional validity. So constitutional basis established under Article 323A, 323B, which were introduced under 42nd Constitutional Amendment Act. Okay, for specialized jurisdiction. No? So this is constitutional basis. Second, their legislative competence. That is, they are established under the laws of the parliament. So Article 323A and B provides the power to parliament to establish tribunal. But to automatically establish nahi hote, parliament has to make the law. Okay, so the validity comes with first constitutional and second statute, that is laws. So parliament empowered to create tribunals for administrative quasi-judicial functions under, ठीक है, ये forget it, concurrent list. Simply even if you remember concurrent list, that is also fine. अगर नहीं भी है तो भी चलेगा. ठीक है. Third, judicial endorsement. ठीक है. Now remember this. अब किसी भी चीज का वैलिडिटी आपको जस्टिफाई करना होगा तो ऑन दीज 3 लाइन्स. 1, constitutional validity. Second, legal validity. Third, judicial validity. ठीक है. They can ask you the question की establish or highlight the validity of the this preventive detention. ठीक है. So constitutional validity will be Article 23. Legal validity, you will be having acts like UAPA. Judicial validity, you mention any Supreme Court judgment ki where Supreme Court has upheld that. Right. Similarly, अगर आपको पूछा कि a validity of reservation. So constitutional validity, Article 15, 16. Legal validity में you can mention any law of the state government. ठीक है, जैसे EWS law. ठीक है. And then judicial में you can give the judicial endorsement like Indira Swani judgment. ठीक है, वैसे. Then this is the recent Tribunal Reforms Act 2021. Again, this was the law. That's it. ठीक है, ये ऐसे ही फोर्सफुल पॉइंट मैंने जनरेट किया है. फंक्शनल वैलिडिटी. ठीक है, कि सप्लीमेंट्री जुडिशियल मैकेनिज्म्स constitutionally valid as long as they do not replace or restrict High Court, Supreme Court. Forget about this point. These 4 are sufficient. So यहाँ पे just remember they can ask you either justification or the validity. ठीक है. So अगर if they ask you justify the reservation policies or justify affirmative action, so constitutional justification, legal justification, judicial justification. ठीक है. That. Then competency of tribunals. Competency matlab basically you have to give their powers and functions. So jurisdiction confined to specific subject matters. जैसे NGT is only limited to environment. ठीक है. Quasi judicial powers to summon witness, take evidence, deliver binding judgments, similar to civil courts. Right, basically that is their competency only ना. Competency मतलब क्या होता है? Powers ही होते हैं आपके. ठीक है. So framing कुछ भी हो, it is completely static. Then no inherent jurisdiction. ठीक है. So can't exercise writ or contempt powers unless confirmed by state. That is basically, अगर आपको ऐसे करना है कि its power are limited to the provisions of state law. ठीक है. जितने लॉ में दिए उतने ही पावर है. It doesn't have any inherent power or it doesn't have any constitutional powers. ठीक है. Then subject to judicial review. Chandra Kumar case. ठीक है. Then within the tribunals also. So you have normal tribunals and you have appellate tribunals. जैसे for example under the insolvency and bankruptcy code, you have National Company Law Tribunal and you have the DRT, right? These two, this is for the company, this is for the individual insolvency, and appeal against them lies against National Company Appellate Law Tribunal. So appellate tribunal mechanism is also there. Okay, and after this there will be HC. After this it will be SC. So their competency lies with appellate tribunal also. Okay, so appellate and supervisory role. Certain tribunals, there's a National Company Law Appellate Tribunal. Okay, and similarly DRAT exercise appellate functions over subordinate tribunals. Okay, again competency and administrative control function under ministries. जैसे NCLT under Ministry of Corporate Affairs. And guided by principles of natural justice. Again, this is their power and function. वही point आएंगे. ठीक है. Then in conclusion, tribunals in line with again उनका purpose हमने कहा था access to justice. Article 39A. You use it. 39A must enhance access to justice while upholding judicial independence and judicial review as constitutional safeguard. ठीक है. This is going to be your conclusion. Clear? Is this clear? Any doubts with respect to the conceptual understanding of tribunals? Sub clear? Okay. So based upon this, I will share the model answer of this. ठीक है. ट्रिब्यूनल का बाकी कुछ मत पढ़ो, सिर्फ इतना पढ़ो, that is सिर्फ just read the model answers. ठीक है. अभी मैंने जो फ्रेमवर्क दिया है, just remember that much is sufficient. Then I think we are still left with this recent one, evolution of collegium system. This we'll do in the next class, the first question. Yes. ठीक है. अब ये this question is for you as an assignment. ठीक है. Now just tell me what you are going to write in this answer and we'll stop today's class. Yes. Who wants to give? वही जितना मैंने अभी तक कंटेंट बताया ना, सेम कंटेंट यू हैव टू यूज. उसके बियॉन्ड कंटेंट है ही नहीं. ठीक है. जो कंटेंट हमने पिछले आंसर में अभी मैंने आपको दिखाया, वही कंटेंट यूज करके आपको ये आंसर बनाना है. सो जस्ट गिव मी द स्ट्रक्चर. आई वांट समवन न्यू. Yes. Who wants to give me the structure of this? Someone new, please. Yes, Mona Lisa. Turn on camera and then give me the answer.
Sir, I'm not very sure, but given the previous question, in this we can talk about objectives, and we can.
What will be the introduction?
So, introduction as the previous question that tribunals, including central administrative tribunals, are quasi-judicial bodies introduced for reducing the burden on judiciary and speedy justice. And then, sir, we can write about the functions of tribunals, which we will mention as objectives. The points under objectives will come as functions. That will be the heading. And then we will mention the issues. Since it is saying that it is now exercising its power as independent judicial authority. So, tribunals, that part we will highlight in limitations.
No. It is functioning, exercising its power as an independent judicial authority. ठीक है. इसके अंडर what you will be writing?
So here we will mention the point that though that L. Chandra Kumar case we will mention that
No.
tribunals
N.
they
Chandra Kumar case will go against this heading. Na? N. Chandra Kumar case means they are not independent. The appeal against them lies with High Court.
yes sir, their independence is limited in that sense. First I'll mention
No,
that they are
first, tell me how you are going to write the points on independent judicial authority. So, Central Administrative Tribunal has independent judicial authority.
so their powers and functions that they are constitutional.
Yes. So, basically, their powers and functions. So, they have first exclusive jurisdiction. So, अब Central Administrative Tribunal, उनका jurisdiction किस पे होगा? They will be having exclusive jurisdiction over
District courts and
no. Central
they
Administrative Tribunals deals with central government
yes sir,
employees.
yes sir, DOPT.
Exclusive
Yes, sir.
jurisdiction over central government employees. Okay. Then they have their powers of civil court. They can issue or they can ask for the witness or they can provide for the binding judgments. ठीक है. Then जो हमने यहाँ पे जो लिखे हैं points, this key quasi-judicial powers, they have their own quasi-judicial powers, they have their own jurisdiction over central government employees. Okay. Then they have the supervisory role over the lower tribunals. Then they are guided by principles of natural justice and have the flexibility, right? वही points है. So that means they are acting as independent judicial authority. Then you give the counter argument. However, their powers are limited. Here you give SC in L. Chandra Kumar case has held that the appeal against CAT lies with the high courts. This is going to be your answer. ठीक है, ये इतना सिंपल है. Let me show you the answer. This is going to be your answer. So if you see introduction, CAT established under 323A and Administrative Tribunal Act provides speedy and specialized justice in service matter of central government employees. उसके objectives the same. Independent judicial authority में क्या आएगा? Exclusive jurisdiction over disputes of central government employee. No, then powers of civil government. Okay, then though it works under administrative jurisdiction of DOPT, it has judicial independence or judicially independent in decision making. Okay, then judicial review authority. Right, CAT can strike down the administrative decisions violating Article 14, 16, 21. राइट, कि जैसे आपके डीओपीटी ने कोई डिसीजन लिया है तो अगेंस्ट दैट डिसीजन द एम्प्लॉय गोज टू कैट and CAT can strike down the decisions of DOPT, right? And then the next is, however, following the L. Chandra Kumar CAT decisions are subject to judicial review by high courts. This is limitation of theirs. You can at the end, if you want, you can highlight the issues and way forward or simply give the conclusion. ठीक है, जरूरी नहीं है वे फॉरवर्ड एंड इश्यूज भी देना. देन इन लाइन विथ आर्टिकल 39A मस्ट इंश्योर. अब जैसे PIL को हमने क्या कहा था, पार्टिसिपेटरी कॉन्स्टिट्यूशनलिज्म या फिर पार्टिसिपेटरी जस्टिस, तो यहाँ CAT is deals with employees. So in line with Article 39A must ensure administrative justice. ठीक है, while upholding judicial independence and judicial review as constitutional safeguards. ठीक है, judicial independence क्यों? Because they work under the ministry, right? So separation of power violate नहीं होना चाहिए. And judicial review as in Supreme Court judgment in L. Chandra Kumar. ठीक है, so this is going to be your assignment question. ठीक है, next the two Lok Adalat arbitrary tribunals and the second need of administrative tribunals. ठीक है, ये दो हम will do in the next class along with local bodies. ठीक है, but read about the tribunal. I will be directly giving you 7 minutes. You will have to write and then I will discuss those answers. That's it. Because we have to finish judiciary in half an hour and then we have to finish the 6 questions of the local government also. Okay, there are 6 questions in last 8 years. That also we have to finish. Okay. So quickly, any doubts? First of all, I just want to have some review with respect to, is this speed fine? Because in about 3 hours, we are covering around 6 to 7 questions. But are you able to understand or are you able to develop the brainstorming and the vocabulary? Okay, it's completely fine even if the speed is low, because I will finish all the 600 questions. But are you feeling that the lectures are productive in terms of change in your approach of reading and in terms of understanding the demands of the questions, okay, with respect to structuring? Okay. So if anybody wants to give the honest review, even if there are any suggestions, I'm more than happy to incorporate them. So if anybody wants to give the review, just raise their hand and I will unmute. I'll give just 2 people. Okay, Akhil, you can unmute and give it. Because I have to incorporate the suggestions. Yes. यार कोई तो रिव्यू दे दो.
Hello, sir. Good evening, sir.
Yes.
Sir, actually, I thought writing answer writing, and I could not make any frameworks, and I felt very difficult to write the answer and complete my question paper, sir. So after joining this course, I developed the brainstorming attitude, like how to segregate that body framework and everything, sir. It's very beneficial, sir.
So
So,
structuring
sir,
wise,
but
it is
structure
helpful.
is very good, sir. It's very helpful. But sir, coming to that notes, sir, that for example, regarding parliament and regarding fundamental rights, were given like around 40-page notes. So how to go on with those that extra, like for example, sir, you gave something regarding some extra topics, sir, in fundamental rights and all. How to
Yes.
go on with those topics, sir?
No, with the similar framework, you just read those. कि जैसे parliament के हमारे whatever the frameworks we applied in the parliament. ठीक है. With the same framework, you try to read. Second thing, while reading the extra topics, you just think, yeah, what kind of the question that they can ask. Suppose in judiciary we don't have a question on contempt of court, but contempt of court is the important topic. So next, while reading the contempt of court from X factor, you think, yeah, what kind of the question that they can ask. Either they will ask the justification of contempt of court or criticism of contempt of court.
Okay, sir.
Right. So while reading, so you just think from the perspective of, so what this for parliament we followed the functional approach. So while reading the points, you just try to link those points with the functional approach.
Okay, sir. Sir, one more question, sir.
Mhm.
Sir, actually, everybody usually will say to make some our own notes, no, sir. So, sir, actually, I felt a difficulty in making these notes. This note start, sir. Actually, this is actually short notes.
Then
There is no need to make it. So,
no need
second
to
point,
make
sir.
the separate notes.
Okay, sir. Then I'll study these notes for multiple times. Sir. These notes, stopper copies,
Yes,
and
just
answer writing
highlight the
frameworks.
important parts. And second thing,
Okay,
if
sir.
you have attended all the 6 sessions, you will
Sure.
find that the same content we are repeating again and again. Same judgments are there.
Okay, sir.
Majority of
Yes,
them.
sir.
Right. Even the keywords are also similar.
Okay, sir.
Okay. Yes.
Thank you.
Tavishi.
Yeah, so as you were asking for the feedback, so it is definitely useful. So because obviously we have read Lakshmikant, so it was just obviously when I was reading Lakshmikant, I was literally thinking by checking the PYQs that how I'm going to write these questions, and Lakshmikant is so like just articles and all those stuff. So definitely it is very helpful for giving like introductions and overall structure. And actually I am making like one-pager notes for every topic like after the class. So right now, like tomorrow, I'll go and like create a one-pager for like for whole judiciary, and obviously set of introduction, set of conclusion, and set of points. So that's it. That is what I'm following. So yeah, thank you so much. It is really
And
helping.
secondly, after the sessions, are you able to finish the expected notes quickly?
Yeah, like I do give a read, like a quick read from that expector, and then obviously your notes, like from the class one, and some points from there. So that is how like 2, 3, or 4 pages, like for a complete micro theme. So that is how like right now my approach is.
Perfect. Okay. Just do one thing, one last thing. You send me any of the answer that you have written before the classes and the latest answer that you have written as the assignment.
So before the classes, like for before these classes, I'm just writing the SM answers.
Yes, same answer, any one that you have written.
Cool.
Yeah, just see purpose of this class is self-evaluation also.
Yes.
Because nobody is giving you the inputs. You are self-evaluating compared to my answers.
Yes, yes.
Right. So again, make that also. You just compare your answers written before the sessions and after the sessions. Okay, then you yourself will know how you are progressing.
Yeah, now I am sending these assignment questions to my mentor actually.
Yes. Who is your mentor?
Deeksha ma'am.
Perfect. Okay. Khushi?
Yes, sir. First of all, I would like to say, yeah, the program is helping me a lot. Particularly in earlier, I had difficulty in interpreting and answering the questions, structuring as such. It's helping me in optional also to understand the demand of the question and how to write answers. But there is one thing I was struggling with. For example, Lakshmikant, I had completed a while ago, and I have not given it a lot of readings. From what my mentor asked me to follow, I read it once, and then now I'm relying only on the expected notes. So even though we brainstorm in class when we build content, but when after that you ask us to write answers, I kind of struggle with it because I completely lack content,
Yes,
like not
that's
half
what I
as good as
told.
the rest of the class.
The only solution for that is time. Okay, you are brainstorming just for 5 days. Well, we have just 5 sessions. So you have started brainstorming just for 5 days. Okay, the only solution is the time. So gradually it will happen. The one thing I wanted to give was the schedule or the timetable that you are going to follow so that you will be able to balance your GS plus optional. First, once you are done with the session, try to finish the X factor notes of that particular chapter on that night itself.
Right.
ठीक है, मतलब आज आपका जुडिशरी हो गया तो आज ही जुडिशरी को फिनिश करो रात में, इवन इफ इट टेक्स 3 to 4 hours, और अगर 12 भी नहीं, 1 या 2 बजे तो भी ठीक है. जस्ट ट्राई टू फिनिश इट ऑन द सेम डे सो दैट आपका नेक्स्ट डे जो होगा, ठीक है, गिव इट कंप्लीटली फॉर योर ऑप्शनल. ठीक है, मतलब आज अगर आपने जुडिशरी का एक्सपेक्टर कंप्लीट किया, कल का पूरा दिन आप ऑप्शनल को दो. जस्ट इन द नाइट you revise judiciary for 1 hour. बाकी entire day you give to your optional. ठीक है. And on the next day also फिर आपका जो भी जीएस का चल रहा है, ठीक है. सो आज आप एक्स फैक्टर पढ़ोगे जुडिशरी का, उसको कवर करोगे. टुमारो you will cover your optional for the entire day. In the night, you will revise judiciary again. And on the next day, अगेन जिस दिन हमारा सेशन होगा उस दिन मॉर्निंग में अगेन यू रिवाइज, यू डिवाइड इट इनटू 50-50. मॉर्निंग का एक स्लॉट यू गिव फॉर योर ऑप्शनल. आफ्टरनून का you revise any of the previous X factor or any of the previous chapter. और जैसे ही at the 4 PM, ठीक है, उस दिन हमारा जो भी होगा, जैसे नेक्स्ट डे नेक्स्ट सेशन विल बी ऑन द लोकल गवर्नमेंट. सो एट 4 PM तक तो लोकल गवर्नमेंट के नोट्स आ जाते हैं. ठीक है. सो फ्रॉम 4 to 5 जस्ट गो थ्रू द लोकल गवर्नमेंट टॉपिक. ठीक है. एंड अगेन सेशन होने के बाद एक्स फैक्टर उसका रात में ही फिनिश कर देना है.
So, for these sessions, we should refer only to the X Factor notes and not Lakshmikant for now. Is it fine?
No, not for polity. For your big 5 subjects: polity, geography, history, economy, and this environment. X factors are supplementary to your standard books. ठीक है. They are not alternative to the standard books. खास करके पॉलिटी को, इकोनॉमिक्स को यू कैन स्किप. ठीक है. ज्योग्राफी को तो एक्स फैक्टर पढ़ो ही मत, सिर्फ आंसर राइटिंग फ्रेमवर्क देखो, वही कंटेंट होगा. बट फॉर पॉलिटी, लक्ष्मीकांत एंड एक्स फैक्टर नीड्स टू गो हैंड इन हैंड because questions have the mix of static plus analytical.
Okay.
ठीक है. So try to follow this schedule so that आपका ऑप्शनल प्लस जीएस का बैलेंस अच्छे से मेंटेन रहे.
Okay, sir.
ठीक है. Okay. Chalo guys, so we'll end today's session. And day after tomorrow we'll finish these questions. Try to finish your assignment question. And day after tomorrow we'll finish judiciary and the local government also. Local government I will try to add tomorrow itself, but or day after tomorrow you just go through it and we'll finish all the 6. Okay guys, good night.